try to tell them, please take the front row of the file. Hey, how's it going? Looking sharp.
Oh, you like that?
I'm a fan.
Thank you. Thank you.
So once they get seated,
Yep. And they can sit in the front row. None of the seats are reserved. So they can sit in the front row. Just take the seat right here.
We're done,
I'm sitting here panicking. I'm not gonna get this.
all the way down, please.
It's okay.
I want to thank our government witnesses for being here today. And everybody is welcome, and I'm glad that we have a lot of interest in this issue, and there has been for several weeks or at least 3 months, I guess. Originally, this hearing was solely going to be focused on our annual oversight of the U.S. Immigration and Customs Enforcement. However, it quickly became evident that more oversight of the administration's entire family separation and reunification effort was needed. So I expanded the hearing to provide oversight of that specific issue as well as just ICE. In April this year, Attorney General Sessions announced a zero-tolerance policy at the southwest border. This policy directed federal prosecutors to enforce our longstanding immigration laws and prosecute all individuals who cross the border against our laws. After all, when the laws on the books are enforced, it protects not only American citizens, but those seeking shelter and protection here as well. Remember, the Attorney General implemented this policy after the Department of Homeland Security reported a 203% increase in people crossing the border against our laws, and that 203% was between March 2017 and March 2018, and a 37% increase from February this year to March of this year, the largest month-to-month increase since 2011. The Attorney General's policy was well-intentioned and simple: enforce our nation's border security laws so that people would stop migrating illegally. We must remember that the border security also affects our national security. However, like many well-intentioned policies, there were unintended consequences. As a result of the administration's zero-tolerance policy, more than 2,500 undocumented immigrant children were separated from their parents. As of last Thursday, 1,442 of those children have been reunited directly with their parents. An additional 378 have been released to other individuals under appropriate circumstances. However, almost one-third of the children, approximately 711, are still in government custody and are unable to be reunited with their parents. Of that 711, some were ineligible for reunification with their families for legitimate reasons. According to the administration, 120 were ineligible because their parents waived the right to reunify. 67 were not released because of what the bureaucracy called red flags, including child abuse and serious felonies that were raised during background checks. Of course, some adults were found to have not been related to the children with whom they were traveling. Over the last 5 months, federal authorities saw a 314% increase in adults and children arriving at the border fraudulently claiming to be a family unit. And of course, this is a dangerous situation, and any policy we have that encourages the perilous practice I just described, that policy ought to be revived immediately. No child should be used as a pawn, subjected to sexual assault, extreme heat, and also criminal behavior by smugglers or traffickers seeking to make a buck on behalf of the most vulnerable. Now, 431 children, the largest number of the 711 who haven't been reunified, were ineligible because their parents had already been deported. The administration claims that all of these parents elected to be deported without their children, but these public reports indicate that many of them may have not made an informed choice to leave their children behind. Some of the reports suggest that these parents weren't presented information in a language that they could even understand. So we ought to be disturbed, and I'm disturbed by these allegations, and I hope our witnesses are prepared to give us thorough answers. Although the administration has mishandled the family separations, it's also important to remember that this institution, the Congress, also deserves its fair share of blame. For years, Congress has failed to take a simple step that could have prevented the family separations we now decry, and that means repealing the Flores v. Reno consent decree. In 1997, as a result of years of litigation, the federal government entered into that settlement known as the Flores case. When the U.S. government first entered into that consent decree, it was a much-needed step towards ensuring the humane and dignified treatment of unaccompanied, undocumented immigrant children children often thousands of miles from their parents. The settlement agreement provided that undocumented immigrant children without their parents could only be kept in federal custody for a maximum period of 20 days. It also required the government to treat these children humanely and ensure the type of quality care we would expect for any child, whether that child's documented or otherwise, undocumented or otherwise, that we ought to expect them to receive that fair treatment. No one, Democrat or Republican, would disagree with that principle, I would hope. However, in 2014, in addition to Flores, a single federal district court in California dramatically expanded the scope of that consent decree by applying it to undocumented immigrant children who arrive with their parents, a move that even the previous administration, meaning the Obama administration, opposed at the time that court case decision was delivered. Under this single interpretation of Flores, the federal government faces a stark Hobson's choice: enforce the law and separate families by releasing only the children after 20 days, or keep families together by engaging in the past administration's catch and release policy. As Senator Cruz, Tillis, and I wrote in an op-ed on Sunday, neither of those options is good choices. That's why we believe the best way to ensure this crisis never happens again is to repeal Flores agreement, but only as it relates to the time limitations governing accompanied undocumented immigrant children. Some of my colleagues will claim that we would end all protections for minor children and just allow the government to detain families indefinitely. So that's not a true interpretation. In fact, nothing could be further from the truth. No one on our side of the aisle wants to end the humane standards of care required by Flores. If anything, given recent news reports, we are more than willing to statutorily enhance those protections. We also want to see families kept in federal custody. We don't want to see families kept in federal custody indefinitely or even long periods of time. As Director McHenry is going to testify, when families are placed on the detained docket, their cases are usually resolved in 40 days. In contrast, when families are released into the interior, they're given a notice to appear at a future immigration court hearing with little incentive to attend. That hearing occurs on average not 40 days, but 700 days after their release, assuming they even show up. And that's just the first hearing. According to the information provided to every single member of this committee during the closed-door briefing, cases can take anywhere from 7 to 10 years to complete. Worse still, almost 80% of the asylum cases are ultimately denied. It just doesn't make sense then to release families en masse and hope that they will show up in the future court date where they will more than likely be denied the right to remain in this country. But, and I'll say this again, if families and children are going to be kept in federal custody, they must be kept in facilities where they will be treated humanely and with the basic dignity that all people, no matter what their immigration status is. Unfortunately, recent media reporting I've seen suggests the federal government is failing miserably in the task that I just described. Over the last few months, multiple news reports have surfaced describing how illegal immigrant children, and in the case of family units, their mothers, have suffered unimaginable physical, mental, and emotional, and even sexual abuse while in federal custody. Obviously, that's unacceptable, and the American people expect better. We hear it from our constituents every weekend we're home. To be clear, this isn't a new issue. Some of the abuse dates back to at least 2012, and several of the most horrific incidents occurred in 2015, 2016. Now, I don't say that to imply that this is all the Obama administration's fault, because it isn't. But clearly, there is a larger systemic issue that needs to be addressed. Again, no one, no matter what their immigration status, should have to suffer such abuse. I am a consistent advocate for victims of domestic violence and sexual assault. So, I'm troubled by these reports. That's why Senator Feinstein and I have sent a letter to the Inspectors Generals of Homeland Security and also Health and Human Services, asking them to open an investigation. We've also asked the Inspectors General to look into practices, procedures, and policies that are in place regarding the custody of illegal immigrant families and children, and to make recommendations to both of us and the agencies regarding potential improvement in these practices. Also, I hope that our government witnesses are prepared to answer questions regarding these incidents, and describe in detail steps that are being taken to ensure no person suffers more indignities again. And none of us on this committee, including this chairman, is going to accept anything less. We've got a lot to cover today, so I'll now turn it over to Ranking Member Senator Feinstein for her opening remarks. But contrary to custom, we're also going to give Senator Cornyn and Durbin opportunities for short statements, because as their chairman and ranking member of the Immigration Subcommittee. Senator Feinstein.
Thank you very much, Mr. Chairman. We're here today because the Trump administration has pursued what I believe is a deeply immoral and haphazard policy that fundamentally betrays American values. This administration has elected to engage in the systematic separation of immigrant children from their parents, and without any plan to reunite them. Even though we're now months into this crisis, we still don't know the official number of children who have been separated from their parents. I hope the administration officials present today finally outline the official total number of children separated, where they are, what the facilities are and where they are that they're detained in, what the conditions are in those facilities, and the location of their parents. The little we have learned has come out of the case in the Southern District of California, overseen by Judge Dana Abreu. According to the joint court filing by the Department of Justice and the American Civil Liberties Union from last Friday, the numbers are 2,551 children aged 5 to 17 taken from their parents at some point. These children were required to be reunited by last Friday, July 26th, and the government did not meet that deadline. Rather, only 1,442 of those children were reunited with their parents. 20 children the government thought they separated from their parent turned out not to have been unaccompanied from the outset. 431 children remain alone in the United States because their parents have already been deported. Shockingly, the government does not even know who or where the parents are for 94 children. This makes clear the government did not track them in the first place. There was no effort to ensure the government knew which children belonged to which parents and where they were located. Another 67 children were not reunified with their parent because of some red flag in their background. However, we don't know whether this flag had anything to do with the safety of their child. an abuse or neglect allegation, or rather some other reason that may be irrelevant to separating the child from his parent. And these are only the children and families we know about. The New York Times reported that the Trump administration may be pressuring people by, quote, using kids as hostages to get people to give up their asylum claims, end quote. They take the children and then tell the parents, if they agree to deport on their own, you can see your child at the airport. If not, we will hold you for months. We don't know when you will see your child, end quote. So it's not an exaggeration to say that the policies of President Trump and Attorney General Jeff Sessions may essentially orphan hundreds of immigrant children. In addition, the Washington Post reported over the weekend that Customs and Border Protection was so unprepared to grapple with this crisis President Trump created, that it called these separated families, quote, deleted family units. When the Customs and Border Patrol sent Health and Human Services information about these deleted families, HHS had no way to track the children. In the end, 12,000 case files had to be sorted by hand to determine which children had been separated and which children arrived in the United States without their parents. Even worse are the stories we heard about these separations and the bad conditions in which they were held. My staff visited a facility in California where children did not have sufficient food or water and were forced to sleep on the cold concrete floor without a cot or a blanket. Unfortunately, despite the public outcry and the rebuke by the courts, the administration has demonstrated it can't be trusted to put the welfare of children above its own hard-lined views on immigration. Therefore, we, the Congress, have a constitutional and a moral obligation to intervene. I've been working with Senator Cruz, Tillis, and Senator Durbin on a narrow bill that prohibits the separation of children from their families, requires an ongoing reporting by the administration, excuse me, and public reporting about what has occurred. The bill would also provide additional judges, lawyers, and resources to ensure that these families are treated humanely and not left ignored in facilities without proper sanitary conditions, food, water, or cots and blankets to sleep on. The bill is straightforward and limited to address the current crisis. I'm hopeful that we are close to an agreement and that the bill could enjoy broad bipartisan support. Mr. Chairman, thank you for holding this hearing. I hope the administration officials are ready today to give us the official figures on reunified children and how it plans to ensure that no further infringements occur on the constitutional rights of the parent and the child to be together. I look forward to the hearing and to the witnesses and working with my colleagues to get legislation enacted quickly. Thank you very much.
Thank you. Senator Corner.
Thank you, Mr. Chairman, for holding this hearing to discuss this important matter and one that directly impacts my state, perhaps the most of any in the country, and of course all of our concern about separation of families. It is ironic to me that last year alone there were 41,500 unaccompanied children who came across the border. We have not heard an outcry from our Democratic colleagues about that, even though the New York Times had reported that about 1,500 of them who had been placed with sponsors are unaccounted for under the current regime, or pre-existing regime, I should say. I recently traveled to Brownsville and Weslaco to get an idea of what the facts were on the ground, since I think many of our colleagues are relying on what I would characterize as incorrect media reports about circumstances on the ground. And at the same time, I spoke with a number of federal and local officials who are responsible for implementing government policy, including Rio Grande Valley Sector Chief Manny Padilla, who's my sort of personal expert on this topic. Border Patrol and all of our professionals at the border have been invaluable in helping me understand exactly what's going on, and I look forward to hearing additional testimony today. I toured 2 of these facilities myself that house teenagers as well as younger children, and I found that these facilities were well managed with caseworkers, mental health professionals, and teachers, 24/7 access to fresh food and water, daily education classes for school-age children, obviously a stark contrast with what has been portrayed by some of our friends across the aisle in the media. One thing I've learned in my time in the Senate is there are few things more complicated than immigration when it comes to public policy. Often the rhetoric is so high and the facts are mangled that the fundamental concept of the rule of law and the imperative that the United States government enforce its own immigration laws and regulate who can come into the country and under what circumstances, those seem to fall by the wayside. The fact that some disagree with those laws and even have gone so far as call for the abolition of the principal law enforcement agency at the border and in the interior, ICE, doesn't alter the fact that these are the laws of the land that our law enforcement officials are enforcing. And they have been passed by Congress and signed by the President. They reflect the will of the American people. I would say, even while many people have been critical of the status quo at the border, even as we work together to try to unify these families, the critics offer no plausible and workable alternative solution at all. And I'll talk about that just in a moment. Family separation at the border is not a new issue, nor is the adoption of a so-called zero tolerance policy. I guess a zero tolerance policy means you're enforcing the law that Congress has written and that the President has signed. President Bush adopted a similar policy. President Obama expanded the program to more locations along the border because they realized that the system of catch and release was an incentive for future illegal immigration into the country. Families were separated under the Obama administration because that's what the law required in certain circumstances. We've even seen more than a 300% increase in adults appearing at the border with small children claiming to be their parents when in fact they are not their parents. And why would they do that? Well, they figured a way to beat the system, and that's why. So despite our political differences, we all agree that the same standard of care and housing that apply to unaccompanied minors should apply to parents and accompanied minors when they cross the border illegally. And thankfully, we do have a solution. I'm glad that to hear what Senator Feinstein said about the bill that Senator Tillis and Senator Cruz have proposed, and I hope that they continue to work on that. We could pass that legislation today. It would allow parents and children to stay in a safe facility while they await their court proceedings and then move them to the front of the line for them to present their case before an immigration judge. If they are entitled to an immigration benefit, then that would be awarded at that hearing. But as Senator Grassley has said, the vast majority of them are released, told to reappear in the future, and escape into the great American landscape, never to be heard from again. So, unfortunately, when we tried to bring up this bill and pass it previously, it was blocked, which is effectively a vote for catch and release. The cartels keep winning. This is their business model. They've figured a way to exploit the vulnerabilities in our immigration laws, and they are making millions of dollars on the backs of migrants as a result. That's what the status quo offers, and it ought to be unacceptable to all of us. So I look forward to hearing from the witnesses today about the progress that's been made and how the administration is screening individuals to make sure we don't put children in additional harm's way. And I hope that maybe, just maybe, the efforts to come up with a solution are not dead, and that we will be able to come up with a compassionate solution to the problem, which is the Keep Families Together and Enforce the Law Act. And it can be passed by both houses and signed by the President without further delay. Thank you, Mr. Chairman.
Senator Durbin.
Thanks, Mr. Chairman, for the opportunity to deliver an opening statement. Thank you for expanding this hearing to address the Trump administration's family separation policy. This policy shows the extremes this administration will go to punish families fleeing horrific gang and sexual violence and seeking refuge in the United States. White House Chief of Staff John Kelly bragged that forcibly separating children from their parents is, quote, a tough deterrent, close quote. But the president of the American Academy of Pediatric Physicians called this policy for what it is: government-sanctioned child abuse. Incredibly, Homeland Security Secretary Kirstjen Nielsen claimed, and I quote, "We do not have a policy of separating families at the border, period." But it was on her watch and under her leadership that nearly 2,700 children were separated from their parents, and more than 700 children still have not been reunited with their families, including more than 400 whose parents were apparently deported and more than 90 whose parents can't be located at all. What will become of these children and their parents, who border agents sadly called, quote, deleted family units? In the name of these deleted family units, 711 lost children, and common decency, I am today calling on the architect of this humanitarian disaster, Department of Homeland Security Secretary Kirstjen Nielsen, to step down. The family separation policy is more than a bureaucratic lapse in judgment. It is and was a cruel policy inconsistent with the bedrock values of this nation. Someone in this administration has to accept responsibility. We can have border security without bullying. We can be safe without treating toddlers as terrorists. And those who say the blame is on Congress, let me remind them, this is a policy which Judge Dana Abreu, thank goodness for his leadership on this issue, this is a policy which he characterized as a chaotic circumstance of the government's own making. Every time there's a conversation with the other side of the aisle, the first thing they want to eliminate is the Flores standard, which for 19 years has guided this nation through administrations of both political parties for the humanitarian treatment of unaccompanied children. It's the first thing that those on the other side ask us to get rid of. It's the last thing we should get rid of. Medical experts tell us that even short-term separation and detention can do permanent damage to a child. 2 weeks ago, Congress received a letter from two of the Department of Homeland Security's own medical consultants. These medical doctors investigated the ICE family detention centers, and here's what they concluded. Quote, they pose a high risk of harm to children and their families. These whistleblowers have told us what they saw in the ICE facilities. The Trump administration claims that they are concerned about what they derisively call catch and release, comparing catching children to catching fish. But there are alternatives to detention that are more secure, more humane, and use far less taxpayer money. It's not too late for this committee to rise up, to step into this situation, and to accept our legislative responsibility of oversight. And we can change the situation very dramatically. Pass Senator Feinstein's Keep Families Together Act, which expressly prohibits family separation. Pass Senator Hirono's Fair Day in Court for Kids Act, which provides unaccompanied children with legal representation in deportation proceedings. How embarrassing is it to our nation to think that there are courtrooms with infant children, toddlers, and preteens standing before judges with no knowledge of what is actually happening to them, their families, and their lives. That is not what America is all about. We need to also pass the Humane Treatment of Migrant Children Act, which I have introduced, requiring ICE to prioritize the detention of those who actually pose a threat to national security or public safety, increasing the funding for alternatives to detention. We do not need internment camps again in American history to intern the children and their families indefinitely, because we won't act here in Congress and this administration doesn't act at all. We need to authorize the merit-based hiring of new immigration judges and couple it with Senator Hirono's bill for legal representation of the minors. I hope today's hearing is the start of a bipartisan effort to confront this administration and end this crisis. It is the least we can do for these deleted families and these lost children.
For Senator Feinstein, I want to introduce into the record letters of opposition to family separation from Dr. Allen and Dr. McPherson. Also, number 2, Amnesty International. Number 3, Los Angeles Unified School District. Number 4, Church World Service. Number 5, the Episcopal Church. And number 6, Chris Polinsky and Donna Abbott for Bethany Christian Services. Without objection, those will be put in the record. I will now introduce our witnesses, and then after I introduce them, I'll ask you to stand because this is an oversight hearing, and we will swear each of the witnesses. In 2016, Ms. Provost was selected as the Deputy Chief of the U.S. Border Patrol. She entered on duty with the U.S. Border Patrol January 8th, 95. 2013, she became Chief Patrol Agent, El Centro Sector, where she led 1,200 employees. In 2015, she became Deputy Assistant Commissioner, the Office of Professional Responsibility. Mr. Matthew Abens was appointed Executive Associate Director for Enforcement and Removal Operations for ICE, February 2017. He began his career as a special agent with the former U.S. Immigration and Naturalization Service. Mr. Albence leads ERO in its mission to identify and arrest and remove aliens who present a danger to national security or at risk to public safety, as well as those who enter the United States without documentation or otherwise determined otherwise undermine the integrity of our immigration laws and our border control efforts. Jonathan White, Commander, is his title, was appointed the Deputy Director of Children's Programs, Office of Refugees Resettlement, January 2017. In that capacity, he manages the Unaccompanied Alien Children Program, which provides care and custody to over 100,000 young people annually who are apprehended by the Department of Homeland Security without an accompanying parent. Commander White advises the Director of ORI, the Assistant Secretary of Children and Families, and the Secretary of HHS regarding unaccompanied children issues. Director James McHenry was named Director of the Executive Office for Immigration Review, January this year. Judge McHenry served as a Deputy Associate Attorney General working on a variety of immigration-related litigation matters and overseeing multiple components reporting to the Office of Associate Attorney General. From 2014 to 2016, he served as the ALJ for the Office of Disability Adjudication and Review in Social Security Administration. Prior to that, he worked for ICE Office of Principal Legal Advisor. Lastly, Ms. Higgins, Jennifer Higgins, is Associate Director for Refugee, Asylum, and International Operations. Directorate. She has served in the federal government for over 15 years, focusing her career on balancing the United States' longstanding humanitarian tradition with its national security mandate. Most recently, she has served as Chief of Staff for the Deputy Secretary, advising DHS leadership on refugee, immigration, national security issues while managing daily operations of the Office of Deputy Secretary. So would you folks please stand and like so. Do you affirm that the testimony you're about to give before the committee will be the truth, the whole truth, and nothing but the truth? So help you God. All have said affirmative. So you folks have 5 minutes, and your entire statement will be put in the record. And for the benefit of the committee, since we have a vote at 12:15, we'll try to keep going and rotate chairmanship with either Republican or Democrats who is ever present, so we can finish. But I'd also ask that we have extended the time for questions from 5 to 7 minutes so that we can move along and not have people go beyond the 7 minutes. So for you folks with 5 minutes each, would you proceed, Ms. Provost?
Yes, thank you. Chairman Grassley, Ranking Member Feinstein, and distinguished members of the committee, thank you for the opportunity to appear before you today on behalf of U.S. Customs and Border Protection. As America's unified border agency, CBP is responsible for securing America's borders against all threats through deploying a multi-layered risk-based approach to enhance border security while facilitating the lawful flow of people and goods entering the United States. As the committee is aware, the U.S. Department of Justice instituted the Zero Tolerance Prosecution Initiative on April 6, 2018. It reinforced what the United States Border Patrol has known for many years. Consequences are most effective when delivered consistently and without delay. On May 5, 2018, the U.S. Border Patrol began increased referrals for prosecutions of all amenable adults for violations of 8 U.S.C. 1325A under this initiative. The law is not ambiguous. Any alien that enters or attempts to enter the United States at a place other than a designated port of entry has committed a violation. Throughout several decades, the U.S. Border Patrol has implemented various enforcement operations and prosecution initiatives as a means to address illegal immigration between the ports of entry. While zero tolerance increased the volume of cases referred for prosecution, we have always had a law enforcement mission and a responsibility to enforce the law. I want to dispel the myth that prosecuting illegal border crossings or separating adults from children in custody is unique to zero tolerance or to this administration. To be clear, we have prosecuted adults who have crossed the border illegally with their children under prior administrations. As with any other law enforcement agency in this country, a parent who is prosecuted for a violation of law cannot bring their children with them into criminal custody. On June 20th, 2018, immediately following the President's executive order, CBP suspended 8 U.S.C. 1325A prosecution of adults in family units and maintained family unity. Following issuance of the executive order, CBP reunified over 500 children in our custody with parents. Although parents are no longer being referred for prosecution under zero tolerance, CBP will continue to prioritize the welfare of the children. Separation may be required if the adult poses a danger to the child, if they have a serious criminal history, or if they have a communicable disease. Going forward, CBP's implementation of the Zero Tolerance Initiative will focus on prosecution of single adult aliens who cross the border illegally. Before taking your questions, I'd like to take a moment to clarify how CBP fits into the interagency process that we will be discussing today. CBP conducts initial processing of illegal aliens in facilities designed to hold individuals for less than 72 hours. These are not long-term detention facilities like those operated by our partners at Immigration and Customs Enforcement and the Department of Health and Human Services. As such, we work closely with ICE and HHS to transfer individuals to their custody as expeditiously as possible. It is important to note that the short-term holding facilities we operate meet the standards of the CBP Transport, Escort, Detention, and Search, known as TEDS, policy, and CBP complies with the legal requirements of the Flores Settlement Agreement. Our commitment to consistent and fair enforcement of the law is demonstrated on a daily basis by the integrity, the unbiased professionalism, and the compassion that the men and women of CBP exhibit towards the aliens we encounter, particularly towards the most vulnerable. We do not leave our humanity behind when we report for duty. As the acting chief of the U.S. Border Patrol, I could not be prouder to represent the men and women who dedicate their lives in support of CBP's mission. I am honored to work alongside them. Ultimately, border security is national security. Enforcement of immigration law is the foundation of a secure border and a secure nation, and I look forward to continuing to work with the committee towards this goal. Thank you for the opportunity to appear before you today, and I look forward to your questions. Thank you.
Chairman Grassley, Ranking Member Feinstein, and distinguished members of the committee. Thank you for the opportunity to appear before you today to discuss ICE's critical mission to protect the homeland and ensure the integrity of our nation's immigration system through enforcement of our country's immigration laws, and in particular, its role in family reunification efforts. Our nation's immigration laws are extremely complex and in many cases outdated and full of loopholes. This often makes it difficult for people to understand all that ICE does to protect the people of this great country. Nowhere is this more evident than in the recent events surrounding the zero-tolerance policy and the reality of the illegal immigration crisis. Today, I would like to discuss the impact that this policy and the Ms. L case have had on ICE ERO operations and the tremendous effort and successes on the part of the dedicated men and women of ERO who perform their duties with professionalism, dignity, and compassion, despite the myriad false allegations and misinformation that are propagated daily by those who do not support the faithful enforcement of the immigration laws passed by Congress. ICE's immigration enforcement efforts are led by more than 7,700 proud, dedicated law enforcement officers and support personnel of ERO. To ensure the national security and public safety of the United States, ICE ERO officers diligently execute our nation's immigration laws in such a way that our limited resources will have the greatest impact on public safety and border security. During fiscal year 2017, ICE ERO arrested more than 127,000 aliens with criminal convictions or pending criminal charges. In real terms, what this means is ERO removed almost 11,000 more criminals from the communities they were victimizing than it did in FY 2016. These aliens were responsible for the following criminal convictions or pending criminal charges: more than 76,000 dangerous drug offenses, more than 48,000 assault offenses, more than 11,000 weapon offenses, more than 5,000 sexual assault offenses, more than 2,000 kidnapping offenses, and more than 1,800 homicide offenses. In fact, in FY 2017, and again in FY 2018, nearly 9 out of every 10 aliens arrested by ERO came to our attention after their arrest for a local, state, or federal criminal violation, with the vast majority of those convicted criminal aliens. On April 6, 2018, the Attorney General announced a zero-tolerance policy for violations of 8 U.S.C. 1325, improper entry by alien, in which Customs and Border Protection would refer aliens it arrested for illegally entering the country to U.S. Attorney's offices along the southwest border for criminal prosecution. In accordance with the standard practice employed by federal law enforcement agencies who arrest individuals for committing federal crimes, CBP transferred these adults to the U.S. Marshals Service pending prosecution. When this occurred, these adults became unavailable to provide care and custody to the children with whom they were traveling. A child without an available parent or legal guardian falls within the unaccompanied alien child definition provided for in federal law, and federal law further generally requires that such UAC be transferred to Health and Human Services within 72 hours. ICE's role in this process is limited to the safe transportation of UAC from CBP custody to HHS ORR. On June 26, 2018, the U.S. District Court for the Southern District of California, in the putative class action known as Ms. LV ICE, certified a class consisting of parents who have been, are, or will be detained in DHS custody, whose children were separated from them at the border and are detained in HHS custody with some exclusions. The court further ordered the reunification of class members with their children that had been separated, absent a determination that the parent is unfit or presents a danger to the child, unless the parent affirmatively, knowingly, and voluntarily declined reunification. By July 12, 2018, HHS and DHS reunified alien minors under 5 years old in the custody of HHS with those eligible parents in the custody of DHS per the court order. Of the 103 children under 5, 57 children were reunified, while the parents of the remaining 46 children were ineligible for reunification under court-approved criteria or could not be reunified at the time because the parent was in criminal custody or had already been removed. As of the July 26, 2018 Joint Status Report filed with the U.S. District Court, Southern District of California, 1,442 of the 2,551 children aged 5 and above whose parents were identified as class members were reunified with parents in ICE custody, and none of these family units have been removed. The court's order to reunite these families under this expedited time frame required ICE to prioritize these reunions over other pressing operational needs, including the removals of individuals determined to have no lawful right to remain in the United States. The reunification timeframe also required an unprecedented level of coordination between HHS and ICE to include the temporary assignment of ICE personnel to the HHS Special Operations Center. Additionally, the 3 ICE field offices serving as primary centers of reunification operated 24/7 to effectuate efficient reunification of children with parents. It is important to note that the current laws and court rulings effectively mandate the release of family units and UAC into communities across the United States. This practice has not only led to aliens failing to appear for court hearings and failing to comply with removal orders, but has also incited smugglers to place children into the hands of adult strangers so they can pose as families and be released from immigration custody after crossing the border. Amending these laws and judicial rulings would enable DHS to maintain family unity throughout the pendency of their immigration hearings. Additionally, if these individuals are ordered removed by an immigration judge, which most are, it will allow for the efficient execution of these orders as opposed to simply adding to an already overwhelming fugitive docket of more than 540,000. Specific legislative changes are outlined in my written testimony. While DHS and ICE are continuing to examine these issues in light of ongoing litigation and recent court decisions, a permanent fix from Congress is essential. Congress must act to update and simplify the parts of our immigration laws that are prone to abuse and incentivize illegal immigration, while providing ICE with the lawful authority and requisite funding to ensure that families can be kept together throughout the course of their immigration proceedings. Thank you again, and I welcome your questions.
Chairman Grassley, Ranking Member Feinstein, members of the committee, it's my honor to appear here today on behalf of the U.S. Department of Health and Human Services. I'm Jonathan White. I'm a clinical social worker, and I'm a career officer in the U.S. Public Health Service Commission Corps. I have served in HHS under 3 presidents. I'm presently assigned to the Office of the Assistant Secretary for Preparedness and Response, and I previously served as the Deputy Director of the Office of Refugee Resettlement for the Unaccompanied Alien Children's Program as the senior career official over the UAC program. And I believe there's a need for clarity on the services that HHS provides every day to unaccompanied children in its care. The quality of care provided by HHS for children is excellent, and the agency takes any reports to the contrary seriously and investigates them appropriately. So all children in our over 100 facilities receive medical, dental, and mental health care. Because most of these facilities are monitored at both the state and federal level, the high standard of care for kids in ORR care is the same as for American children in licensed residential care settings across the country. We provide all the children in our care programming that includes education, recreational activities, including outdoor sports, arts and crafts, appropriate entertainment, and physical activity. Children in our facilities receive 3 meals a day, as well as snacks, and at all times, HHS knows the names and locations of all children who are in ORR care. In the last 2 months, HHS has provided nearly 85 members of the House and Senate and more than 50 media outlets with tours of our funded facilities. After touring our facilities, both members and staff have commented on the quality care that we provide. Now, I know there's been some frustration of late over some member of Congress's ability to access any facility at any time. Our top priority is the children in our care, and in an effort to minimize the strain on resources and disruption to the children, we've continued the policy that was begun in the last administration to require any visitors to coordinate their visits with us in advance. And we thank this committee for your assistance in the coordination of the many facility visits in the past few weeks. Where these children are concerned, the unfortunate reality is this. The children we serve every day in the UAC program have, in many cases, been targeted by gangs, they have been smuggled, and they have been trafficked. Smugglers and traffickers often arrange fraudulent claims of parentage of a child to allow someone to enter the United States more easily. The children we serve are at high risk for victimization and human trafficking in their home country, on the journey here to the U.S., and yes, also here in our country. In fact, the Senate has investigated this problem. Led by Senator Portman, the Permanent Subcommittee on Investigations helped uncover how in 2014 a number of children were placed in the hands of human traffickers who forced them to work nearly every day for 12 hours a day. These children were threatened with death if they did not work, so it's important to us. Making sure we never repeat mistakes of the past is why our #1 priority will always be the safety and well-being of children in our care. Now, we understand that, understandably, public attention has recently been focused primarily on the issue of separated children. But most of the minors for whom HHS is responsible crossed into this country alone. In 2017, we had 40,810 children referred to our care from DHS. The average length of stay that they were in our care was 41 days. As of this morning, HHS has 11,316 minors in our care. ORR releases the majority of children in our care to sponsors, and these are typically parents or close relatives. In 2017, 49% of those children were released to a parent, 41% to a close relative, I mean a sibling, an aunt, an uncle, or a grandparent, and 10% were released to a more distant relative like a cousin or to a family friend. Since the President's executive order, the Secretary of HHS has directed HHS to take all reasonable actions to comply with court orders, including in the Ms. L case, which require reunification of children with eligible class members, that is parents, from whom they were separated by the Department of Homeland Security, and to prioritize child safety and well-being when doing so. On June 22nd of this year, the HHS Secretary directed the Office of the Assistant Secretary for Preparedness and Response to help ORR work with DHS and its operating divisions to reunify children in ORR care with adult class members. So the key steps in that coordinated plan for reunifying parent and child in government custody include, #1, identifying the parent's location. #2, confirming that there is no cause to doubt parentage. #3, reviewing the results of criminal background checks and the child's case management records to make sure there are no concerns about the child's safety going to that parent. And #4, interviewing the parent to confirm the parent wants to be reunified with the child. And if those checks establish eligibility, then we transport the child to the parent for family reunification. This effort required us to stand up a 55-member incident management team that I have led in Washington, and field teams of federal staff and contractors totaling more than 200 responders. HHS has now completed the reunification process for those parents in ICE detention who are eligible for reunification within the definition of the court. However, we know our work is not over. We continue to make all efforts in cooperation with our partners to reunify parent and child whenever possible, and when not possible, to work to identify another relative or appropriate sponsor who can quickly and safely take care of the child. We are undertaking this challenge of separated children consistent with the best interest of the child standard that has been our mission since 2002, when HHS inherited the responsibility for these youth. I want to close by thanking the women and men who work in HHS facilities to care for children. Their dedication guarantees that these children, many of whom are fleeing violence, gangs, and severe poverty in their home countries, and many of whom have suffered trauma both at home and on the difficult journey, to guarantee that those kids get care, services, and safety. Thank you for letting me speak today, and I'm glad to take any questions you might have for us.
Mr. Chairman, Ranking Member Feinstein, and other distinguished members of the committee, thank you for the opportunity to speak with you today regarding the Department of Justice's role in the current situation related to family reunifications. This is an important and sensitive subject, and we welcome this opportunity to address it from the Department's perspective. The mission statement of the Department of Justice is to enforce the law and defend the interests of the United States according to the law, to ensure public safety against threats, foreign and domestic, to provide federal leadership in preventing and controlling crime, to seek just punishment for those guilty of unlawful behavior, and to ensure fair and impartial administration of justice for all Americans. The Department's mission is exemplified by playing 3 roles relevant to the current situation. First, the Department rigorously enforces the criminal laws passed by Congress. Through the U.S. Attorney's offices, in conjunction with the U.S. Marshal Service and the Bureau of Prisons, the Department plays a crucial role in enforcing these laws and seeking punishment for those guilty of unlawful behavior. The Department's role applies no less to immigration crimes than it does to other categories of crimes. Section 13 of Executive Order 13767 directed the Attorney General to establish guidelines and allocate resources to ensure that border prosecutions enforcing the immigration laws passed by Congress are a high priority of the Department. On April 11, 2017, the Attorney General issued a memorandum to all federal prosecutors outlining certain immigration-related offenses, including improper entry under 8 U.S.C. 1325, as high priorities. On April 6, 2018, the Attorney General issued another memorandum entitled Zero Tolerance for Offenses under 8 U.S.C. 1325A. This memorandum directed federal prosecutors along the southern border to adopt a zero-tolerance policy for all offenses referred for prosecution under Section 1325A by the Department of Homeland Security. The Attorney General's memo remains in force today, and illegal or improper entry, among other immigration crimes, remains a prosecution priority of the Department. Furthermore, the President restated the prioritization of prosecuting illegal entry crimes in Executive Order 13841, which also reiterated that the current policy is to rigorously enforce the immigration laws passed by Congress. The Department of Justice does not dictate which cases are referred for prosecution by the Department of Homeland Security, nor does it maintain a general exemption from criminal prosecution for parents. The Department has no operational or logistical role in either the care or the processing of aliens for removal, regardless of whether they are adults or children. Accordingly, it also does not play an operational or logistical role in the reunification process. Criminal proceedings are separate from civil immigration proceedings, and prosecution for illegal entry under the auspices of the zero-tolerance policy by itself does not necessarily foreclose an alien's ability to make a claim to remain in the United States. Consequently, depending on the particular circumstances of an alien following a prosecution, he or she may make such a claim or, alternatively, may elect to be removed from or to voluntarily depart the United States. If an adult alien subject to expedited removal makes a claim to remain in the United States, that claim is generally directed to the Department of Homeland Security in the first instance. As the claim progresses, it may eventually be reviewed by an immigration judge in the Executive Office for Immigration Review, which is the second role played by the Department in the current situation. Unaccompanied alien children placed in immigration proceedings pursuant to law will also have their cases heard by an immigration judge. As the issue of family separation and reunification has reached the federal courts, the Department of Justice has a third role as a litigator providing representation to those agencies that do provide care for aliens subject to removal. Consequently, I may be limited in my ability to speak to certain issues today, either because they are currently in litigation or because they are more properly directed to another agency. Nevertheless, the Department of Justice recognizes the seriousness of the present situation and is appropriately advising both the Departments of Homeland Security and Health and Human Services as they continue to abide by any orders issued by federal courts on these matters. The current immigration system faces numerous legal and logistical challenges. Added to these challenges is the current situation regarding family separations and reunifications. Nevertheless, as the formal title of Executive Order 13841 indicates, which is affording Congress an opportunity to address family separation, the Department of Justice stands ready to work with Congress to answer these challenges and to improve existing laws to avoid a reoccurrence of the present situation. And I look forward to answering the committee's questions today. Thank you.
Thank you. Chairman Grassley, Ranking Member Feinstein, and distinguished members of the committee. Thank you for the opportunity to testify at today's hearing alongside my colleagues from DHS, the Department of Justice, and the Department of Health and Human Services. My name is Jennifer Higgins, and I am the Associate Director of the Refugee, Asylum, and International Operations Directorate at U.S. Citizenship and Immigration Services. My testimony today will focus on the role of USCIS in the expedited removal process, which is the primary framework in which we encounter families arriving at the southwest border. The Immigration and Nationality Act generally requires the expedited removal of individuals arriving in the United States without proper documentation. In 2004, DHS expanded expedited removal to individuals apprehended within 100 miles of a U.S. land border and within 14 days of illegal entry. All individuals placed in expedited removal proceedings are subject to mandatory detention and prompt return to their countries of origin. However, if a single adult or a family unit indicates to CBP or to ICE that they have a fear of persecution, torture, or return, the law requires that these individuals be referred to USCIS for an assessment of their protection concerns. This is commonly referred to as a credible fear screening. Credible fear interviews are conducted by specially trained USCIS officers. These officers comprise a professional cadre within USCIS dedicated full-time to the adjudication and screening of protection claims. They have diverse educational and employment backgrounds, from military veterans to Peace Corps volunteers, former ICE trial attorneys to former nonprofit immigration attorneys, from prior law enforcement officers to former social workers. Despite their diverse backgrounds, they are all driven by the mission to provide this country's protection to those who are eligible while remaining fully focused on ensuring the integrity of the mission and protecting our country against those who seek to do us harm. All officers conducting credible fear screenings are extensively trained in national security issues, country conditions, interview techniques, credibility determinations, fraud detection, and U.S. and refugee and asylum law. During the credible fear interview, these officers question individuals about their identity, their fear of persecution or torture if returned to their country of origin, and whether there are any circumstances that may make them ineligible for asylum. USCIS also conducts security checks, including biographic and biometric checks, and coordinates with ICE and other law enforcement authorities if there is any reason to believe that an individual may have engaged in criminal activity or poses a security threat. Under U.S. law, an individual establishes a credible fear when he or she demonstrates that there is a significant possibility that he or she could establish eligibility for asylum or withholding of removal or relief under the Convention Against Torture. If the individual establishes a credible fear, USCIS places that individual into removal proceedings, where he or she can seek asylum or other forms of relief before an immigration judge. Therefore, a positive credible fear screening determination by USCIS does not confer any immigration status. It is simply a screening process employed to identify individuals who may potentially merit protection, while the decision on asylum eligibility or other forms of relief for such cases rests with an immigration judge. If USCIS determines that an individual does not have a credible fear, he or she is subject to removal, unless the individual requests that an immigration judge review the USCIS screening determination. Our role is limited, but it is an important one, to screen in those who qualify, screen out those who don't, and protect the integrity of the process. USCIS has more than 100 officers conducting credible fear screening interviews around the country, conducting on average 350 to 400 interviews each day. In response to the President's executive orders, we have deployed our staff continuously to 10 major detention facilities in the border region, including 2 family residential centers in Texas, to carry out credible fear processing. Since fiscal year 2013, our dedicated workforce has completed over 385,000 credible fear cases under the extremely short timeframes demanded by the expedited removal process. Our officers have demonstrated and continue to demonstrate extraordinary commitment to the mission and U.S. immigration law, working tirelessly alongside ICE and CBP to keep pace with increasing volumes of credible fear requests while producing high-quality decisions. Thank you again for the opportunity to explain the USCIS role in the expedited removal process. I would be happy to answer your questions.
I've already said we'll have 7-minute rounds, and I hope that members will stop at the end of 7 minutes, but you folks can answer the question if the 7 minutes has run out. I'm going to start with Mr. Albence. Your family residential centers referred to as places to keep children behind bars. This description seems to be in contrast to the law and the standards, what they require. ICE family residential centers, to my understanding, are structured like communities with family residence, recreation, medical and dental offices, cafeterias, commissaries, even a hearing room for judges or lawyers to, or judges to give full attention to the claims of residents. I'm also concerned about recent reports of abuse. The New York Times claimed that migrant women were being sexually abused by guards while in custody. If true, that's unacceptable, as I said in my opening statement. What steps does ICE take to investigate and respond to all allegations of abuse at these centers? And what steps does ICE take to protect or prevent such abuse and punish offenders? Let me also add this question. What steps are being taken by ICE to ensure that no undocumented immigrant families suffer from forms of physical or mental abuse while in ICE custody?
Thank you for your question. Our family residential centers, as with all of our detention facilities, undergo a very rigorous inspection process and oversight process. Any allegations of abuse or wrongdoing that occurs in any detention facility, to include the FRCs, is automatically reported to our Joint Intake Center. That is for reporting of allegations that go directly to DHS, Office of Inspector General. The Office of Inspector General has the ability to take any of those allegations for investigation and will do so if they feel that there's evidence to warrant such an investigation. Those that they choose not to investigate could be investigated by ICE's Office of Professional Responsibility, which also has the authority to conduct investigations. In addition to that, the normal oversight processes that our detention facilities have include the Department of Homeland Security's Civil Rights CRCL. We have the Office of Detention Oversight within ICE, Office of Professional Responsibility. We are required to be inspected and meet licensing standards. We have detention service monitors that work for ICE, that work for our custody management branch, that go to these facilities on a daily basis. We have officers in these facilities on a daily basis. With regard to the FRCs, I think the best way to describe them is to be more like a summer camp. These individuals have access to 24/7 food and water. They have educational opportunities. They have recreational opportunities, both structured as well as unstructured. There's basketball courts, there's exercise classes, there's soccer fields that we put in there. They have extensive medical, dental, and mental health opportunities. In fact, many of these individuals, the first time they've ever seen a dentist is when they've come to one of our FRCs. When they leave an FRC, they leave there with 7 sets of clothing for each individual that was in that FRC. While they are there, they do have all sorts of access to pro bono legal opportunities. There's a legal orientation program that is there, and they are able to avail themselves of that. There are many NGOs that work in those facilities, are there on a daily basis to provide them assistance and support once they are released back into the community. So I'm very comfortable with the level of service and protection that is being provided in the FRCs. And I believe the FRCs, there's video on our website where one can go onto there and see the conditions of those FRCs.
Yeah, I think you've given a pretty thorough answer, but I'd like to have you commit to have your agency provide a detailed report on what steps are being taken to end any alleged abusive practices and protect undocumented immigrant families. I hope you can say yes to that.
Yes, sir.
And I think your description would be what's required by federal law. If you haven't described things that are required by federal law or your own internal policies, give me an answer on that, but I think you've kind of described that, haven't you?
Much of what I described is required under federal law. A lot of these are PREA standards. ICE actually has some of the most rigorous detention standards in the country. That includes other federal and state agencies for our detention facilities. So some are rooted in law, some are rooted in policy.
Attorneys, I hope, are allowed to confer with residents, and residents are allowed to make phone calls about their immigration cases.
Yes, that's correct.
Okay. Still continuing with you, sir. You mentioned that many parents elect to be removed and leave their children behind. This is a difficult concept for me to understand as a parent. and grandparent, but the reality is that many undocumented migrants do leave their children behind. Some of my colleagues will say that ICE is coercing these parents into leaving their children behind. A recent Politico article states that as many as 75% of the parents deported without their children didn't give informed consent for that action. I'd like to better understand how reunification options are explained. So are ICE officers coercing parents to be deported to leave their children behind, as Politico suggested?
No, there is longstanding ICE policy which dictates how reunification may occur for an individual that is being detained and going through an immigration process. So if the adult is being detained in an adult facility, obviously the child cannot be kept in that same facility. There are times during the course of that immigration process in which the adult may be bonded out, whether by an immigration judge or for another a medical reason perhaps, where they will have the ability, if bonded out, to proceed to sponsor their child out of HHS through the normal processes and procedures that HHS has. If that individual is held in custody during the pendency of their immigration process, and at the end of that process is ordered removed by an immigration judge, that individual will have the opportunity to request that their child be removed with them to their home countries. We work closely with consular officials. We work closely with attorneys that these individuals may have to help facilitate that. But a great many of these individuals do not wish to have their child return home with them. The reason most of these individuals have come here in the first place is to get their children to the United States. Many of these individuals have spent $5,000, $10,000, their life savings, to have these children into the United States. They've paid smugglers, they've paid transnational criminal organizations, they've subjected themselves and their children to a high level of risk in the journey north. So once they have gotten that child here, many times to another parent that is here in the country illegally or other relatives that are here in the country illegally, a lot of times they will not want to take that child back with them and risk having to make that journey again. They've succeeded by getting their child here. And as we have seen with these individuals that were arrested, many of them during the zero tolerance program, many of these individuals are repeat offenders. They've been deported previously. They've got criminal histories here in the United States, meaning they've been living here in the country illegally, were caught, arrested, and removed. It's easier for them to leave their child here, to go back to their home country and try to re-enter this country again illegally as a single adult as opposed to with a child.
Okay. Senator Feinstein, and then I'm going to step out a minute. Senator Hatch will be after Senator Feinstein.
Thanks very much, Mr. Chairman. I'd like to have a conversation with you, Commander. My
Yes, ma'am.
history in this goes back to the year 2000, when I happened to be watching television, and I saw a young Chinese girl, maybe 12 years old, before an immigration judge in Seattle. She was manacled hand and foot. She couldn't understand the judge. The tears were pouring down her face. That was in the days when people were coming in containers. Some died, some survived. She was a survival. And we did a bill called the Unaccompanied Alien Child Protection Act of 2000, which took children out of ICE and put them in HHS. The bill also provided for some pro bono and legal help, which didn't make it into the final bill, which I'm now told was the Homeland Security Act of 2002. So Senator Hirono has picked that up and done that part of a bill probably better than I did it, but I'm happy to be her co-sponsor. And so there's a long and emotional history. I was so struck this morning by the fact that there are 11,316 minors in care of HHS today. It's clear that we have a huge problem, and my understanding those numbers are down too somewhat. How did all of this happen? It appears to me that when Border Patrol agents were separating the families at the border, they did not adequately document the family units. So to your knowledge, with the children you have, what kind of documentation do they bring with them when they're arrested or cross the border or go through a port of entry, wherever it is, that is helpful to you?
Thank you, Senator. So the mechanism for referring a child into the care of ORR by a DHS agency, typically CBP, but in some cases it can also be ICE, is that they have limited access to the IT system that's used by the UAC program, which is called the UAC portal. They have the ability to refer into that portal, and they can actually, in the case of CBP, they can make a referral starting with their system. So there isn't, we...
Just say it like it is. Don't worry about it.
This is a novel situation. It is, there have always been some minors who have been separated, typically because of serious criminal charges faced by the parents or other concerns.
Let me interrupt you. We had a briefing that Senator Grassley arranged for some of us, and Senator Durbin, I know, was there, and I think Senator Leahy, and we were briefed, and I thought the number was 15% to 20% at the highest of the children.
That is approximately the recent number. It's been about 15 to 20%.
Okay.
Prior to our recent reunifications, it's a smaller proportion now.
Okay, so thank you. Continue. So the majority of children aren't in that category.
Correct. Even at the point where we launched our reunification effort, 80% of the minors in care are traditional unaccompanied alien children. That is to say, those who entered the United States without a parent or legal guardian and were apprehended without a parent or legal guardian, separate from those who were apprehended with a parent or legal guardian and separated.
So how do you identify them? How do you connect them with a parent? It seems to me the system is unworkable, or we wouldn't be where we are today.
The systems were not set up to have referrals include parent information. So in some cases, when the referral from CBP was made, it noted that the minor was separated and may have had parent information such as the name and alien number. What we have done in this event is we had a data team look at ICE, CBP, and HHS data and scrub those systems against one another in order to identify the matching of parent to child.
Stop for a minute. That alien number, when it comes with the child, how old does the child have to be to have an alien number? And how do they carry it with them?
So every minor that is referred to us is referred with their own alien number. The alien number is a unique identifier of any person in the immigration law enforcement system.
How about a baby?
A baby that was referred to us would also have an alien number.
And where would that alien number be on the baby?
It would not be on the baby. It would be in the electronic referral of the child to our care.
How do they connect?
I'm sorry, how do they
How
connect?
does the electronic referral connect with a child, let's say 8 months old?
So the referral is made to our 24/7, 365 intakes desk in ORR, which identifies the best bed nationwide for that child based on that child's age and needs. That information on the location of that bed is then conveyed back to CBP, and typically, in the case of most border apprehensions, in most cases, it would be ICE ERO that brings that child to the location that we've designated to receive the child.
Now, let's go to the 11,316 minors in care today.
Yes, ma'am.
How many are under the age of 5?
I don't have that number with me. I'd have to go back and look
Could you
up.
get that definitive number to us?
Absolutely, we can do so, I'm sure.
I have the numbers from the joint filing by ACLU and DOJ, and I want to be quick. Just tell me, in children in care with ORR, parent waive reunification, 120. Reunification precluded by plaintiffs, 7. Adult red flag from background check, 21. Adult red flag from case file review, 46. Adult release to the interior, 79 children. Adult outside the U.S., 349. These are likely parents deported, and adult location under case file review 94. Is this filing correct?
Those
I
numbers,
could give you a copy of it if you want.
that reflects the numbers at the time of the filing.
Are they correct numbers?
They were at the time of the filing. Those numbers have changed subsequently.
I
But
think,
they are correct as of the date
My
of the filing.
time.
They're correct.
okay, I'd like to get the changes. Thank you very much, Mr.
Senator Hatch.
Well, thank you, Mr. Chairman, for convening this important meeting. I think it's really this important hearing. I think we can all agree that the last several months have been a challenging time for immigration enforcement. The family separation crisis at the southern border has revealed some significant problems with our immigration laws and the ways they're administered. I think the President did the right thing last month when he signed an executive order to put a halt to the separation of parents and children who enter our country unlawfully. I led a letter to the Attorney General the previous day with a number of my colleagues asking for a halt to family separation. And I'll be following up this week with another letter requesting information about the administration's reunification efforts and the barriers that remain to reuniting children who were separated from their parents. Now, I hope we can all avoid the urge to make this a political football. There are very strong feelings on all sides of this debate, as there should be. These are extremely important issues. But finding a productive way forward requires cool heads and a willingness to compromise. Now, I applaud Chairman Grassley and Senator Tillis, Senator Cruz, Senator Feinstein, Leahy, and so forth for their efforts on this front. And I hope discussions will continue so that we can find a solution that is fair to families, responsive to humanitarian needs, and consistent with our rule of law. Now, let me just make this question for the whole panel. In fact, this is a question for whoever happens to have the information on hand. And if you don't have an exact number, I'll take an estimate. What percentage of individuals who enter our country unlawfully are families with children?
Thank you for the question, Senator.
Sure.
Right now, approximately 25% of the individuals that we apprehend are part of a family unit. Another 15% of our total apprehensions are unaccompanied children.
How has that percentage changed in recent years? And if the percentage has increased, what in your view is the cause of the increase?
The numbers have been increasing over the last few years. This started in 2014 when we saw a large spike in both areas. We started to see rises in 2010 in unaccompanied and then 2013, but the biggest spike was in 2014. There are many push and pull factors that lead to this issue, and I would say that, as discussed earlier, the fact that family units and children cannot be detained or do not make it to court within 20 days is certainly a pull factor that is leading to the increase in those numbers.
Okay. Now, without new legislation, does the administration have any choice but to resume so-called catch-and-release policies for individuals caught entering our country unlawfully with children? Do they have any other choice? Anyone?
If you're talking about detaining family units
Right.
or detaining children,
Right.
per the Flores settlement agreement, those individuals cannot be detained for a period longer than 20 days.
Right.
As the chief mentioned, it is virtually impossible to have an individual's immigration hearing, the entire process, which may include a credible fear review, be completed within 20 days. As a result, we have no choice but to release these individuals out into the community, and they would then go to the non-detained docket, which would be years down the road before they might have a hearing.
I see.
Yeah, with an ankle bracelet.
Well, it's my understanding that part of the problem here is that the Central District of California has ruled that the Flores consent decree applies to both accompanied and unaccompanied children. Now, anybody could answer this, but in your view, and I'd like all of you to take a crack,
in your view, is that the best reading of the Flores decree? And that is, do you think the Central District of California got it right? And if not, does the administration have any available avenues for appellate review? Now, I understand that the Ninth Circuit looked at the question and sided with the Central District. Did the government seek cert? If not, is there any available avenue by which the government might be able to seek certiorari? Admittedly, the interpretation of the consent decree is not a typical subject for Supreme Court review, but this is a question of pretty significant nationwide importance. So anyone who take a crack at that, I'd appreciate it.
As you may know, the President's executive order in June, or earlier this year, among other things, directed the Department of Justice to seek modification of the Flores decree. The department did file something. The judge rejected that. And we're still debating or discussing internally what our next steps are, what options we should take.
Well, we got to move forward on that, it seems to me. Let me just ask one other question. We've heard a lot about alternatives to detention programs and the allegedly high success rate these programs have in terms of the percentage of participants who appear for removal proceedings. Are there reasons to think that if we expand these programs, the percentage of participants who appear for removal proceedings will remain the same? And are there reasons to think the percentage would decrease? And how are participants selected for these programs?
The alternative detention program has proven to be a fairly successful program with regard to having individuals appear for appointments with ICE and to appear at hearings. However, the ultimate goal of the immigration enforcement continuum is the execution of the judge's order at the end of those immigration proceedings, whether the individual is granted a benefit and then goes to CIS and gets their green card or whatever benefit they're entitled to, or, as in most cases, when the judge orders the individual be removed, that we are actually able to effectuate that removal. ATD has proven to be woefully unsuccessful in leading to removals. In fiscal year 2017, there was $183 million assigned to the ATD program. That led to 2,430 removals. That's over $75,000 per removal. In contrast, a removal of an individual that's been held in detention for usually the average length of stay of 30 to 40 days costs about $1,600. So if you have a process which, at the end of it, the judge's order means nothing because the individual doesn't appear after he receives that order or continues to file frivolous appeals or we're unable to locate him, we haven't accomplished anything except spend a lot of taxpayer money.
Yeah, my time is up, Mr. Chairman.
Senator Leahy, I just was wondering if this is your order.
Thank you, Mr. Chairman.
You gave this to me or my staff.
I didn't give this to you.
You know,
Is this okay?
it seems stranger and stranger as we hear this. I know the president's policy is systematically separating infants and toddlers from their families seemed to me to be a profoundly betrayal of American values, something I hadn't seen with any administrations, Republican or Democrat. And I think that's why so many in this country stood up and said, that's got to change. So now we're trying to pick up the pieces. After a colossal mistake, we try to pick up the pieces, 700 children separated from their families. So, Chief Provost, prior to being directed to separate families under the zero tolerance policy, what instructions did the White House or Secretary of Homeland Security provide your agency for how to ensure that every single separated child be reunited with their parents? I ask this because early 2017, the administration began considering this. April of 2018, Attorney General Sessions announced the zero tolerance policy. And about a month later, the DHS Secretary approved and instructed DHS to refer 100% of the parents for prosecution. What kind of guidance did you have?
Thank you for your question, sir. Under zero tolerance, the guidance was, just to be clear, 100% prosecution for all amenable adults. It was not focused on any one demographic. I can tell you during the time frame of the 45 days between May 5th and June 20th that we apprehended approximately 42,000 individuals.
Did you have guidelines that you had to follow? Had you been given guidelines from either the Attorney General's office or the Department of Homeland Security?
In alignment with the zero tolerance that came out from from DOJ, then our secretary did on May 5th put out a memorandum, and we began working with our partners at the Department of Justice to prosecute.
Was there specific guidance of what to do?
Of what to do, I'm sorry, sir, in relation
With
to...
the separating children?
That is not an area that CBP deals with in the aspect.
Somebody has to deal with.
We refer those individuals. We deal with the prosecution. As the commander said earlier, we have a system of record that we input all of the information into to include the alien number of the individual and any family members. We also have juvenile coordinators who work hand in hand with staff at HHS.
I know, I've heard of the stories.
And with ICE.
Year-old infants being before the judges, and it's almost Kafka. We have, so you pick them up. They're removed from their parents, but there has to be some kind of a system to ensure the children could be matched to their parents, doesn't there?
This is where we are working closer with our partners at HHS and at ICE. The initiative was a prosecution initiative, and our focus was on the prosecuting all amenable adults.
Well, listen, I was a prosecutor, and I've never known a zero tolerance. Any prosecutor ever wanted a zero tolerance on anything because it doesn't work. There's not a one-size-fits-all. With the children, I mean, here's an easy way. Here's a really easy way to do them. I mean, Chuck E. Cheese uses things like this to check parents and their children when they're there. There wasn't anything like this, right?
We provide information on all family members through our system of record, E3, to HHS individuals. So if we have a child, they have a specific alien registration number that is given to them. So do the family members. And in our system, we do track family members of any, whether it's children or adults.
Why do we have separated children? They can't find the parents.
I would have to defer to my partners. My focus is on border security and the apprehensions. We have short-term holding facilities.
Anybody want to tell us why, if we have?
At no time did we not know where any adults that were in ICE custody were. However, once an individual is no longer within ICE custody, we do not track that individual, whether that individual is here in the United States and was released on bond, or whether that individual is deported to a foreign country.
So if you have children, then you have children, you don't know where the parents are. They could go years, maybe forever, being reunited. Is that correct?
That's the commander.
Commander?
The system that we are required by law to follow in HHS is that governed by the Trafficking Victims Protection Reauthorization Act. Until Judge Abreu ordered us to effect reunifications with parents in ICE detention, all those parents in ICE detention were, while they were detained, ineligible by law to serve as sponsors. So to be clear, we always had a system in HHS to find sponsors, generally parents or close family members, for all the children in our care.
Do we have any children now in custody where we don't know where their parents are?
There remain a few where we do not know the location of the parents, particularly those where the parents have been removed or voluntarily departed the United States. We have a larger number of those.
Let me ask you another question, maybe Mr. Albans. ICE has a Homeland Security tip line, but they've got a call center in my home state. It's been traditionally focused on receiving tips on major crimes like terrorism and human trafficking. which we'd all agree with, tips on terrorism, human trafficking. But now the tip line has changed, and you could call it, I did, and you have options. Number one, report suspected undocumented immigrants, like maybe your neighbor or somebody who's working down the street. If you go all the way down to number 4, report terrorism. Go all the way down number 6, report crimes against children. Go all the way down to number 8, report gang activity. Does that seem like a great ordering of priorities?
As you know, Senator, ICE is divided into 2 operational components, Homeland Security investigations and enforcement and removal operations. I oversee ERO. I can't speak to what HSI does, but we certainly take it back for the record and get you an information.
No, but just answer the question. Does that seem like, to you, a great priority? Number 1 priority, report your neighbor who might be an illegal immigrant. Number 8, report gang activity, or number 4, terrorism. Just on the face of it, does that seem like priorities are set straight?
Again, I can't speak to it. I don't think the number that the individual is supposed to press has anything to do with the relevancy of the information that they're trying to report. I believe they get over 100,000 tips a year. I think it's a way that they can categorize those tips so they know where to farm them out.
Senator Cornyn.
Okay.
Thank you all for being here. I want to start by thanking you for your service to our country, and not only you, but the people you represent. I know you do your best to enforce and administer the laws that Congress writes and that are passed into law, and that's what you are doing today, and that's what the people who work with you do. It's not your fault that Congress has been unable to come up with a more sensible system of enforcing our immigration laws. It's our responsibility, not yours. So please convey that, our gratitude to the people that you're here representing. Chief Provost, let me ask you, are the organizations that smuggle drugs, weapons, traffic in women and children for sex and forced labor, and who smuggle economic migrants in the United States, are those one and the same organization, or are these different organizations?
As you know, Senator, there are numerous different transnational criminal organizations. However, what we have seen over the last few years is they have spread out into doing more than just one thing. So we have organizations who smuggle drugs and also smuggle illegal aliens across the border. They treat individuals like a commodity, not like people. And it is, of course, of great concern to us. The dangers of crossing our border, I believe you know very well. It's a very dangerous border. This year alone, we have rescued over 2,800 individuals. And tragically, we've lost at least 180, and that does not include the individuals that perish on the dangerous route through Mexico.
So the cartels, the criminal organizations are commodity agnostic. Would that be a fair characterization?
I would say so, yes.
And right now, they're making millions of dollars under the status quo. If they can effectively circumvent our immigration enforcement, or if they can exploit vulnerabilities in our law and successfully place illegal immigrants into the United States and reap thousands of dollars for each one they do that, they're benefiting tremendously economically under the status quo. Would you agree with that?
Yes, sir.
So, Mr. Albitz, what if we just decided to abolish ICE? What would be the impact on our country in terms of public safety?
The public safety impact would be huge. In addition to the immigration enforcement that we do, which, as I mentioned previously, arrested 127,000 individuals with criminal convictions and arrests last year. Our Homeland Security Investigations Branch does a significant amount of work, all tremendous work with regard to drugs and narcotics, child predators, cybercrime. I would also say that you cannot have strong border security with a void in the interior. If an individual knows that they can come to the country and try and try and try and eventually get past the Border Patrol, and that there is no chance of any enforcement being taken against them, then you will never have border security. What, in effect, you're saying, if you're getting rid of the interior enforcement arm of immigration enforcement, is that you're saying you want border security, you want the Border Patrol to make all these arrests and stop people there, but once they get by the Border Patrol, let them go. So in effect, you're not against illegal entry, you're against attempted illegal entry, because once the entry is made, you don't want us to do anything on the inside.
And if ICE was no longer in existence and no longer enforced our laws in the interior of the United States, would the primary victim of that be the minority communities in which many of these people operate?
These minority communities are the primary victims now, because these individuals are involved in all sorts of gang activity and other criminal activity, and generally they commit those crimes against those in the same communities in which they reside.
So, Ms. Provost and Mr. Albence, if our primary goal is family unification, which we all share, why not just keep the child with the adult and enforce the law?
Senator, as Mr. Albence said earlier, the issue there is that under the Flores settlement agreement and the determination that was made by the courts by a court in 2015, we can no longer detain individuals longer than 20 days. No child, not just unaccompanied children, but also those who are accompanied.
So that means that if somebody violates our immigration laws by entering the country illegally, if they bring a child with them, you can't detain them longer than 20 days, correct?
That's correct.
You must release them and rely on their promise to reappear at some future date for a court hearing if they claim some immigration benefit like asylum, correct?
That's correct. What the Flores settlement agreement has basically done is effectively impose judicially mandated catch and release for individuals that have UACs and family units.
And that's the status quo now unless Congress acts?
That is correct.
Okay. So, Ms. Provost, let me ask you about the interaction between drug smugglers and human smuggling. As we all know, the opioid crisis is wreaking terrible havoc on Americans, both prescription drugs and heroin, which is the next drug of choice if you can't get prescription drugs because it's cheaper and it's more available. The DEA said that 16,000 Americans died of heroin overdoses in 2017. 90% of that heroin comes from Mexico, according to the DEA. So, according to some information that I've received, the drug smugglers actually use the fact that Border Patrol and other law enforcement are tied up administering and seeing to the needs of these minor children and family units as a way to distract Border Patrol from smuggling of heroin and other illegal drugs into the United States. Is that correct? Has that been your experience?
Yes, sir. That has been my personal experience, and it is certainly the experience that my men and women are having to deal with today.
So once again, in addition to the huge fees charged by these cartels to smuggle people in the United States, in addition to that, they are also profiting by the poison that is being exported from places like Mexico into the United States that's killing Americans as we speak. Correct?
Yes, sir.
Senator Durbin.
Thank you, Mr. Chairman. On June 26th, Judge Dana Abreu, appointed by Republican President George W. Bush, ordered the reunification of separated families. He concluded, and I have his quote here, "The practice of separating these families was implemented without any effective system or procedure for tracking the children after they were separated from their parents, enabling communication between the parents and their children after separation, or reuniting the parents and children." Commander White, your expertise is public health. Were you consulted, was your agency consulted before the zero tolerance policy was put into effect so that you could address the issues that Judge Abreu raised?
Senator, to be clear, my last day at ORR was March 15th, so it's about 3 weeks prior to the announcement. As of that date, neither I nor, to my knowledge, any of the staff who reported to me were advised of the impending zero tolerance policy announcement.
Were you aware of the fact that this zero tolerance policy was going to be proposed or implemented?
I was aware because I had been in discussions for, at that point, more than a year, of discussions of policies which could result in the separation of children from family units and their referral as UACs. However, those were only policy discussions and as sort of proposals. Many proposals are discussed in federal executive branch agencies that never become a policy. As of my last day in the role, when I would ask questions about family separation, I was advised that that was not the policy of the United States.
And you left when?
March 15th, 2018.
And this policy started in April?
That's my understanding, sir.
Mine too. So 2 weeks before this policy was implemented, you were basically told this isn't the policy. And from what I hear from you, you're not aware of any efforts to consult with public health professionals about the disposition of these children and the treatment of these children under this policy.
I couldn't speak to whether there were or there weren't. I could only say that there were none with me.
I think Judge Sabrow's observation is accurate based on what you've told us here. It's hard to imagine, isn't it? The United States of America says we're going to start separating kids forcibly from their parents. But we're not going to set up a system of tracking those kids so we can find them or matching them back up with their parents. We're just going to separate them. 2,700 children were separated. And as Senator Lay and others have pointed to, there are some very basic ways that we could have kept track of the children and the parents in this age of not only computers, but plastic bracelets. They didn't do it. Let me ask this question, if I might, about the parents in this situation. Last Thursday, the administration stated in a court filing that the parents of 431 separated children in HHS custody are not in the United States, and the parents of more than 90, the lost children, cannot be located at all. On Friday, this federal judge, again quoted, "The government is at fault for losing several hundred parents in the process." Now, according to Secretary Nielsen of the Department of Homeland Security, she said, quote, "All of these adults who left without their kids left based on a decision to leave their children," end of quote. Mr. Albence, you made a similar claim in our last briefing. However, last week, an administration official told Politico that as many as 350 of the 431 parents may have departed the United States without being given the option to take their kids with them. Mr. Albence, do you stand by your and Secretary Nielsen's statement, and do you have documentation showing that each parent made an informed decision to leave behind their children?
As indicated previously, it has been long-standing ICE policy for parents who are being removed from this country that have a child here to have that child go with them should they choose to do so. That is a process that is followed, has been followed for many, many years. As part of that removal process, we can't remove an individual to their home country without a travel document. If that parent wishes to take that child with them, we would also work with that consular officer to help facilitate the issuance of a travel document. Additionally, in order to get the travel document for that adult, those adults are interviewed by the consular officer. One of the questions the consular officers ask—
I've got to cut to the chase. Is there a piece of paper where you're saying that a parent abandoned a child, leaves the child behind? There clearly must be a piece of paper signed by that parent before our government would let that happen.
Right.
Is there documentation for what you claim?
Right now, the form that we're utilizing, per the Ms. L decision, or preliminary injunction, is an ACLU-developed form approved by the court.
I know you can get to yes or no, and that's what I'm looking for.
We are using a form developed by the ACLU and approved by the court to document these parents' decisions.
When did that start?
I don't have the exact date. I want to say that form itself was July 6th, but don't quote me on the date. Prior to that, we had additional forms that we had developed that we utilized for that purpose.
So you could produce for us documentation showing that these parents, 431 parents, abandoned their children voluntarily.
We can go into each file and see the records that are there, whatever paper records are in there, as well as what's in our electronic system of records, where they will make notes, the officers will make a note that the parent declined reunification as well.
Now, the premier case on this, Miss L, involves a woman from Congo whom I've met personally, whose daughter was separated from her by 2,000 miles, and she was basically bargained into giving up her rights to even claim asylum in this country if she ever wanted to see her daughter again. That was what she faced, and that is why her case continues to this day. Let me ask one last thing. There's a Mr. Sandweg who used to have a job in ICE under the Obama administration who made an observation which I would like to quote to you, and it relates to your testimony, Mr. Albans, about the diversion of resources from ICE to this effort of reunifying children. And here's what Mr. Sandwig said. The beneficiaries of Trump's policy are drug smugglers, coyotes, and gang members. We're burning our resources on this family effort. I was last Friday at the Customs and Border Patrol with their agents at O'Hare as they are sifting through millions of packages coming into the United States, trying to stop the flow of narcotics and fentanyl and other things into our country. I said, what's your number one need here? He said, more people. My guess is that most Americans would say to you and your agency, stop the drugs from coming in here, stop the fentanyl for goodness sakes, and stop separating kids from their families and spending your resources and personnel on that effort. Wouldn't you agree?
Well, again, ICE has two operational components. The operational component of Homeland Security investigations, which does fentanyl investigations, which does human trafficking and smuggling investigations, is not involved in this effort. I would further note that the reason we had to put these additional resources to this effort was a result of the judge's order. We had...
No, it was a result of the creation of this policy by this president.
We had...
Zero tolerance policy was not created by this judge. The separation of 2,700 parents from their children is not the judge's decision. It was your agency's decision and the administration's decision. Blame other people if you wish, but this started with somebody in the White House with a bright idea that turned out to be a disaster.
What I can tell you is that ICE has longstanding policy for the reunification of children and parents at time of removal. What has changed as a result of this judge's order is that we needed to create a new process to facilitate that reunification now and release those parents from custody who would have otherwise been detained during the pendency of the removal proceedings. That's what was different.
Senator from South Carolina.
Let's see if we can kind of organize our thoughts here. The current state of law in the United States is as following. If you're an unaccompanied minor and you're apprehended by the U.S. government, you can only be held 20 days. Is that correct?
No, sir, Mr. Senator.
That's
An
not correct.
unaccompanied minor apprehended must be referred by DHS within 72 hours to the Office of Refugee Resettlement in HHS. There is no time limit on how long that minor remains in ORR care. ORR, however, is a child welfare agency, not a law enforcement
So
agency.
what happens to the kids once they're referred in 72 hours?
They receive services and care in our system, and each child is provided a clinician and a case manager. That
Do
case,
they ever go back to their home countries?
some do return to their home
What
country.
percentage?
I don't have that percentage.
Well, it seems to me that's kind of important. So is there a difference between the policy regarding Mexico and Canada? If you pick an unaccompanied minor up at the Canadian borders, it's the same as if you picked them at the Mexico border?
If I may, Senator, if we apprehend a juvenile, an unaccompanied juvenile from either Mexico or Canada, dependent upon the juvenile's ability, and if they are old enough and have the ability to make a determination, they can be returned to Mexico and or respectively Canada. For any other unaccompanied children, they have to be put into proceedings.
So if you were a parent living in a bad spot, if you could get your child into the United States, chances are they stay here?
Yes, to your prior question to the commander, I don't have the exact number in front of me, which we certainly get for you, but I believe the last number I saw, you're looking at about 1.5 to 2% of all UAC are ever returned to their home countries. And generally, that's once they've aged out and are now adults.
Okay. So if you can get your kid here, you got like a 98% chance that they'll stay in America. Is that pretty much the number?
Unless they get involved in some sort of criminal activity where they come to our attention, then generally, yes.
So you get a family that's coming here to apply for asylum. We say, I'm sorry, we can't accept your application. They come in illegally. is it the law of the United States they can't be held over 20 days?
Yes, a family unit cannot be held longer than 20 days.
So if you're a family unit, there's two ways. If you live in a bad spot, you send your kid here by themselves, chances are they're going to stay here. If you come as a family, you can only be held for 20 days. Is that correct?
I would defer to my colleague in relation to what all ICE has the ability to do, but yes, that
Isn't
is
that
my
the Flores
understanding.
decision?
Yes, the maximum time we would be able to hold you is for 20 days.
Okay, what percentage of the people who are let out after 20 days actually show up to their hearings?
I don't have that number in front of me, but we certainly
How
get
do
it.
we
It's a
not
small
have this
percent.
number?
It's a small percentage.
Well, I mean, like if it, why don't we know that? So is it less than 10%?
Again, I'd have to get it back for you. I don't have it in
Does
front of me.
anybody know?
The immigration courts, we don't track divisions or distinctions made by DHS.
Wait a minute, time out. You bring your family, you get caught at the border, 20 days under the current law, because of the Flores decision, you have to be released to somebody. I mean, you get out, right? We can't hold you over, is that the law?
Under
Does
Flores,
anybody know?
yeah, children who are with their parents can be held in a DHS family
What about the
residential center.
parents? Do they have to be let out in 20 days?
The Flores decision does not require that.
What happens to the parents?
If the parent is going to be held in ICE custody, they would have to go to an adult detention facility, and the child would have to go over to
But
HHS.
does the parents have to be let out in 20 days?
No, the parent, only if they're with their child.
Okay, so the best thing you could do, this is bizarre. So you come here as a family unit, the adults can be held until their hearing. They're not required to be let out by the Flores decision, is that correct?
That's correct.
What would you recommend we do about this?
We give us the authority to hold the family as a family unit during the pendency of their immigration removal proceedings. And at the conclusion of those proceedings, if those individuals are granted an immigration benefit, they are released and go on and pursue that benefit. If they are ordered removed, we detain them until time of removal, and we remove them.
That might deter some people from bringing their children here. Do you all agree with that?
Yes, sir, I would say that it would.
What's the main reason we have 11 million illegal immigrants in America? What brings them here? What are they here? What's the main magnet?
Well, Senator, there are numerous push and pull
I
factors.
said the main reason.
I could not say specifically
I'm going
which
to say
reason.
something, see if you agree. The main reason most people come here is to find a job. Does that make sense to y'all? I mean, y'all are the experts.
Sir, for the children that we see in ORR,
I'm not talking about children, I'm talking about adults. Does anybody disagree with that? The main magnet is economic opportunity in America versus where they come from. If we don't know that, how are we ever going to solve the problem? Anyway, I think that's the main reason. If you abolished ICE, who would be the biggest winner, Mr. Albans?
Smugglers?
Okay. And if you don't have E-Verify controlling who gets a job, do you think you can ever fix this, Ms. Provost?
No, sir.
So you can build a wall of 100 miles high, people are going to go under it, over it, or around it, as long as they can get a job here in America. Do you agree with that?
I would say there's many aspects to border security and many factors, push and pull factors that impact it.
Okay, thanks.
Senator Whitehouse.
Thank you, Chairman. Mr. Chairman, I think you were probably in the closed-door briefing that we had when I asked the previous panel of witnesses what went wrong. Not one was able to answer one thing that had gone wrong in this calamity. Two of our witnesses were witnesses in that same proceeding. So I'd like to ask the question now that people have had a chance to think about it a little bit longer. And let's just go right across the line, as simply as possible, in a nutshell. What went wrong here, Ms. Provost?
Sir, we were directed to do 100% prosecutions on amenable adults. The vast majority of the adults that we prosecuted, in fact, approximately 85%, were single adults.
Is that a responsive answer to my question? What went wrong?
Sir, it's our responsibility in CBP to make the apprehensions and turn subjects over to our partners at ICE and or HHS.
So as far as you're concerned, nothing went wrong?
I'm not saying that, but I don't.
You're not saying anything that did go wrong, and the obvious solution is that if nothing did go wrong, that
our responsibility is the border security aspect of it, and for when individuals violate the law,
Mr. Albans,
enforcing the law.
what went wrong?
Yes, Senator, as we spoke last time, as I indicated, both ICE and HHS have longstanding policies and procedures, some governed by law in the case of HHS, which dictate how reunifications occur. If that individual is not in ICE
This has
custody.
been a calamity. What went wrong? Why?
I'm answering your question, sir. If an individual is not in ICE custody, there's a standard practice that they follow in order to sponsor that child out of HHS. If the individual is in ICE custody, there is a standard practice that is followed with regard to reunification
procedure.
for a purpose at time of removal. Correct. As I indicated with
Commander White, what went wrong?
Senator, what wrong is that children were separated from their parents and referred as unaccompanied alien children when in fact they were accompanied.
Mr. McHenry, what went wrong?
I would have to defer to the responses given by my colleagues. They have the operational and logistical knowledge as to what happened.
Doesn't the DOJ have an interest in the consequences of the decision the Attorney General made? Aren't you looking at what went wrong?
As I alluded to in my opening statement, we don't play an operational or logistical role. The policy was based on prosecutions. I'd have to defer to my colleagues' responses because they're on the front lines.
You wash your hands of this one, huh?
I don't know that I would describe it that way. I mean, we are advising them
Another way to
appropriately.
describe it.
We are advising them appropriately in the litigation.
Ms. Higgins, what went wrong?
As I noted in my opening statement, our role in the process is a very narrow one, although it's important. So our role is to be able to provide protection screening to individuals who are seeking asylum in this country. So I would have to defer to my colleagues on the logistics of the policies in place today.
Is the judge following the law in the orders that are being given to solve the reunification problem? Mr. McHenry?
As that is a matter of litigation, ongoing litigation, it wouldn't be appropriate for me to answer that.
You can't even tell me if the judge is following the law in his decisions?
We are abiding by the orders. We've advised our clients to abide by the judge's orders.
Okay, that's a pretty good answer. So you assume that they're lawful. Are you appealing them?
Any further comment on it wouldn't be appropriate because the litigation is ongoing.
Is there anything that would have prevented your organizations from going through the process that the judge has been forced to undertake to prepare for this? You did it afterwards when the judge told you. Couldn't you have done it beforehand if there had been an implementation period?
Senator,
White?
we were able to effect the reunification of large numbers of minors with their parents in ICE detention. In fact, all the eligible minors who had parents in ICE detention, working in partnership with ICE, because the judge ordered us to not follow the Trafficking Victims Protection Reauthorization Act. We could not have done that without him ordering us to do that. We would have been prevented by statute.
And was that foreseeable?
Was what foreseeable?
The consequences of following that act?
The UAC program exists to provide care to children and to reunify them with sponsors in this country. But reunification with those in ICE detention is not consistent with statute until we receive the order from the judge.
Ms. Provost, when was the first date that you heard of Attorney General Sessions' April 6th decision to require zero tolerance?
Senator, personally, I first became aware on April 6th.
Okay. Mr. Albans, when did you first become aware of the April 6th decision?
I would say be on or about that date.
Mr. White, you said March 22nd before you left, and you didn't know at the time, so I think you're...
No, sir, I left ORR on the 15th of March. I became aware of the announcement of the zero tolerance policy when it was on television on the 6th of April.
Mr. Henry, I assume you knew, since you're working with the Attorney General, that this was going to take place before April 6th?
We were consulted or advised that it may be a possibility in case it had any operational impact on us.
When were you first notified that it was going to, that this decision would be taken?
It would be only a few days before it came out, so on or about April 6th.
Ms. Higgins, when did you first find out about the Attorney General's April 6th decision?
I found out about the decision when the decision was announced, but I would note that our director has indicated that he was asked to make a recommendation once the decision was made to prosecute illegal border crossers, how to implement that.
Mr. White, could I ask you, I just have a few seconds left, how many cases are you aware of separated children, separated pursuant to this policy, in which it turned out that there were fraudulent claims of parentage and there was, in fact, no family relation between the child and the person claiming parentage or family relation? What is the number?
Sir, I don't have that number with me, but we are aware of a number of those cases. As a reminder, the total number that we have identified of separated minors included both minors separated prior to and subsequent to the announcement of the zero tolerance policy. The judge's order does not distinguish between those. We have, but I don't have with me, the number who were determined to be fraudulent parents. That did occur, and indeed that is an endemic risk that all of these agencies work to prevent.
May I have the actual number when you have a chance? I know you don't have it now, but could you get it to me as a question for the record?
Sure. If you provide that question to Assistant Secretary for Legislation, I'm sure we'll take that back for action.
Mr. Chairman, is that a good enough answer? Well, I'm not sure. I think I've just asked a question at a hearing, and I've been told that if I go back and put it in writing to somebody else who's not at the hearing, I might get an answer. I'd like to actually have a commitment here to get an answer. I think that's appropriate in a Senate hearing.
Might ask the same question. It'd be appreciated by this chairman if you'd respond to each person separately.
So you'll get me the answer? Thank you.
Senator Tillis.
Thank you, Mr. Chairman. Thank you all for being here and for the hard work that you do. I'm trying to figure out if I can get all these numbers normalized, because I've heard some numbers from a few to a few thousand quoted here. I think people could walk away accepting the answer that best suits the narrative. So can you explain to me again, one, the number of children who have not been yet reunified with their parents?
Yes, sir. So,
and then I want to talk about the reasons why.
sure. So of the 2,551 children in ORR care at the time of the judge's decision who were determined to have been separated, or who we had indications of separation based on our analysis, 1,992 of those, as of this date, are no longer in ORR care. 559 remain in ORR care.
So again, 559 are the number of children who may be able to be reunified with their parents based on the information you have that have not yet?
No, sir. That would include both those who we have not yet reunified, but who may be eligible for reunification, such as the remaining minors who might have parents who had been released into the interior, or the remaining minors who might have parents who had returned to home country. But it also will include some minors who remain in ORR care who were determined not to be eligible to be reunified with their parents.
Because of the circumstances related to their parents?
Typically, it would be based on either that we have not yet, that we had reason to doubt that they actually were the parents, and we're in the process of determining that by objective standards, which I can talk about if you need me to, but more often it would be due to an identified safety risk to the child, and I'll be very specific. So this would be based on ICE's summary that they provided to us of NCIC fingerprint background check summary. So, for example, specific parents who were excluded in this basis, we call it red flagged, included, for example, those who had prior convictions for criminal convictions for child abuse, those with prior criminal convictions for child sexual exploitation, those with prior criminal convictions for crimes such as rape, murder, and kidnapping. Criminal history by itself, per se, is not necessarily a bar to reunification, but a criminal history that clearly demonstrates a real threat to a child, that is. So these would be among the reasons that a person would be ineligible based on ORR determination, which is that there are significant doubts as to actual parentage, or significant doubts of the safety of the child based on criminal history, or the child making a statement, for example, to their mental health clinician in our care that the parent had abused them or they'd otherwise been harmed.
So in the same way that in your responses to, maybe it was your opening statement, that the ORR care that these children are a part of is up to the same standards that we would have for any child or U.S. citizen, and the same sort of standard for having these children be reunified with their parents in terms of ultimately the care and safety of the child. Is that fair to say they're getting applied similarly?
Senator, the standards that we are required under court order to meet for reunification of children are actually not as high as the standards required by TVPRA. I can give specific examples, but for example, the court ordered us to consider putative parentage as parentage unless there was specific reason to doubt parentage. However, in the ordinary course under TVPRA, we have to establish parentage, typically by birth certificates that are verified by the consulate of the home country or other objective verification. That's an example. So this is why it takes longer to reunify children with their parents in the ordinary process than was permitted under the court-ordered time frame here.
Okay, Mr. Albans, this may be for you or Mr. McHenry, but we've made progress on some language here, working with Senator Feinstein and others on the other side of the aisle to try and figure out a way to get reunification done. And Mr. McHenry, we've talked about authorizations for judges up to, I think, an aggregate of 700, a ratio of 2.5 attorneys to each judge, so that we've got the right kind of resources to support clearing the docket. We've talked about making sure that we have standards for family detentions that are up to the level of quality we want versus the tent cities or the other things that people would lead you to believe we would stand up to house families. Those are things that we've found agreement on, but for some reason we have a different opinion about how we would have to have language that tailors the application of Flores to the population of children whose parents are in detention. Now, some say that you don't need that language. Mr. Albans, what would you say to that? That you wouldn't need that clarification to be able to keep the family unit together pending processing through the adjudication process?
Not having seen the exact language, it'd be a little bit difficult to comment, but I will say that any language that allows or requires us to release those parents prior to the completion of the removal proceedings is going to merely exacerbate our existing situation.
We were talking about just the opposite for this population, to allow the children to be with the parents that would be over the 20-day detention period. But and I think the docket's somewhere around 40 to 60 days if we prioritize families. So it's quite the opposite. We're just trying to give clarity for that segment of the population. Is that really what the department needs to be able to keep these families together?
Again, it's difficult to speak on any particular piece of legislation. I would say that what we have seen in our experience is if there is a way that family, if there's a time frame, whether it's 20 days or 40 days, if that family is able to delay their process, which requires them to be released prior to the termination and culmination of that process, then that will happen. We have seen frivolous appeals on individuals on non-detained docket where individuals are here for 10, 12 years filing frivolous appeal after frivolous appeal because there is no reason not to, because they're out in the community.
Final question I have, and it's probably for all three of you in my remaining time, the alien identifier, it sounds like to me we also have a disconnect where some are thinking that we just separate these children and we're not trying to do our best in the documentation to keep these family units identified in either electronic or paper records. So are we not doing, Chief, I think you said that you try to link whoever comes together who's detained or whoever's apprehended together, and it sounded like through the process all the way over to HHS that there is identifying information to find that unit of people who were apprehended initially at the border. Did I hear that right?
Yes, sir. So when we apprehend somebody, they are given each individual is given an alien registration number. Within our system of record, which is E3, our agents go in and also identify family members related to those individuals in both the narrative of what is called a Form I-213 and make reference to those so that we can go back and look at the alien registration of the specific individual and find out who else is associated with them. That includes members beyond just parental. And parental or legal guardian are the only ones that we would refer or that we would be making how do I want to say, separating the family unit into unaccompanied. They come with cousins, they come with uncles, aunts, those types of cases as well.
So it does sound like it flows through the process. It may be slightly more sophisticated than the Chuck E. Cheese's model in terms of trying to identify families and people who were apprehended. Anybody disagree with that?
Neither these information systems nor these programs were specifically built to effect reunifications of children with parents in ICE custody. So this had to be a novel process because this is not how these programs were designed.
Okay. Senator Klobuchar.
Thank you very much, Mr. Chairman. Senator Tillis at the beginning of his remarks used the word normalization, and he meant it with numbers. But that word struck me just because there's nothing about this to me that seems normal. I have kids in my state that were separated from their parents. I was down at the border and met with a number of families, including a mom who was fleeing an abusive husband in Honduras, separated from her 10-year-old son, said she never thought she would see her son again, but because of the court order and because of the work of people who've been pushing this issue, she did see him again. And he, in only a way that a 10-year-old would do, said he knew that he would always see his mom again and gave her a hug. And I was also struck by something that I don't think has gotten enough attention, and that is the response to this cold-hearted policy from the American people. Sister Norma running that operation down in McAllen with Catholic Charities, the thousands of volunteers, Americans from all over the country who have responded and gone down there and volunteered, the diapers, the food, the clothes, everything we've seen. So I hope that it's not lost that despite this policy, which was an enormous mistake, Americans have responded, and not just the people in this building. So my first question, Mr. Albence, is that at the time of last week's second court order deadline, for the administration to reunite families that had been separated. 711 kids ages 5 to 17 had not been reunited with their parents, including 431 children whose parents were no longer in the U.S., likely because they were deported. We have one like that in Minnesota. And I want to address the issues involved in locating parents who have already been deported to Central American countries. Other parents may feel they need to relocate in a different part of their countries to escape violence after they've been deported. So how is the administration working to address these challenges if these kids simply want to find their parents and go back? We have one like that.
As Mr. McHenry indicated on the prior question, since this is a subject of the ongoing litigation, I unfortunately can't provide you any different details until such time as that becomes part of the record.
Okay, so we don't know. All right, Commander White, I'm concerned about what efforts, if any, have been made to ensure that sibling groups stay together. Having a parent forcibly taken away is traumatic, but then to lose your sibling is also terrifying. And when I traveled to Texas, I actually spoke to a family that had just been reunited, a brother and sister from Honduras. The girl was taken to Florida while her brother was detained in Texas. Does HHS have a policy in place regarding sibling groups? And if so, can you provide the policy to the committee?
Yes, ma'am. So it is the policy of ORR to keep sibling groups together wherever it is possible to do so. I don't know the specific case you're talking about. Frankly, I'm a little surprised because except when there's sort of a healthcare issue or something else, it is very, very rare that we would see sibling groups separated in ORR care.
They were a 15-year-old girl. I met them, so.
Right. No, I'm just saying that case surprises me, so I couldn't speak to that particular
Well, they're
case.
together now, so.
There is a policy, and like all of the ORR policy and procedure, it is public-facing and online, but it is consistent with the best interest of the child to keep sibling groups together wherever possible. and that is generally a priority in placement of children.
Okay, thank you very much. Ms. Higgins, like many of my colleagues, I was deeply troubled by Attorney General Sessions' decision last month to overturn key asylum protections in the Matter of AB case that helped victims of domestic violence seeking asylum in the U.S. I'm a former prosecutor. This was one of our major focuses in our office, and we would often have immigrant victims where either in sexual assault or domestic violence cases, perpetrators would deliberately prey on them because then their perpetrator could say to them, well, I'm going to report you if you don't have sex with me, or I'm going to report you if you go forward and go to the police with the fact that I'm beating you up every day. And so that's why this is so important when you look at this issue. After Attorney General Sessions decided to review the relevant precedent, I sent a letter signed by Senator Feinstein and several of my colleagues urging the administration to preserve these critical protections. And since then, I have seen the need for the protections. I mentioned the case early on of the 10-year-old kid separated from his mom who had fled an abusive partner. Many survivors of domestic violence have taken extraordinary risk to escape their abusers by seeking asylum in our country. What can you say about the need to ensure that those seeking asylum have the opportunity to make claims for relief?
Thank you for the question. I would just note that our officers adjudicate each and every case on a case-by-case basis based on the facts. They are required to ensure that they're abiding by all statutes, regulations, and precedent decisions. As far as I understand Matter of AB, there is nothing in that that prohibits someone from seeking asylum. What our officers are tasked with doing is making sure that they are reviewing all relevant evidence and making those case-by-case determinations.
But what are the implications of the decision to overturn the precedent?
I think it's a bit early to tell. I don't know if my colleague from DOJ would like to.
Do you think
opine
it's going to
further
make
on
it
that.
more difficult for those asylum seekers who are fleeing domestic abuse to get that asylum?
I think it's difficult to say, and there are a number of reasons for that. It's quite possible that individuals who would no longer qualify under Matter of AB as a particular social group might qualify under one of the other, one of the other protected grounds. Furthermore, in the credible fear context, an individual could qualify for the protections under the Convention Against Torture, in which case no nexus is required.
But the screening process has changed, right? The credible fear screening process?
Our process has not changed. Our officers still interview individuals. They address all of the facts and evidence before them, and they make case-by-case decisions.
So you're saying you don't think it's going to make any difference at all that the Attorney General reverse this decision?
I'm saying it's very difficult to predict, and that because individuals may qualify under other grounds, it will be challenging to really assess the
Was
impact.
USCIS involved in the decision the Attorney General made to overturn this precedent?
I personally was not involved. I understand that the DHS was party to the litigation and provided a briefing, but I suspect our DOJ colleague might be able to talk more about who the AG consulted.
Okay.
As Ms. Higgins indicated, the Department of Homeland Security is a party to every immigration proceeding, but they're represented by U.S. Immigration and Customs Enforcement in removal proceedings. I couldn't speak to whether ICE consulted with USCIS or not. That would be something that would be up to DHS.
Okay, well, I'll just ask it in writing at the end and try to get to the bottom of that, because, again, this policy and this policy change to me was just unprecedented and unnecessary, just like the policy of separating the kids. Thank you.
Senator Booker. Pardon me, Senator Hirono.
Thank you very much. Your testimonies today have made pretty clear to me that the government had no plan to reunite the separated children from their parents. In fact, Commander White said that if the judge had not ordered the reunification, it wouldn't be happening because these children suddenly that we made orphans and became UACs were within HHS custody, and that is reunifying these children, UACs, with parents, because presumably they're UACs because they had no parents. If the judge hadn't forced the reunification, it wouldn't be happening. So, Mr. Albans, what was DHS's long-term plan for these children once they were separated from their parents?
Again, ICE has had longstanding policy that facilitates reunification of a parent and a child at the time of removal. That has been our policy, and that would have been the process we would have followed and had followed prior to this judge's order.
You mean that even without the judge's order, you would have proceeded to reunify as appropriate 3,000 children who you just separated from their parents?
If the adult had gone through the immigration court process, and at the end of that process had been ordered removed by an immigration judge, the individual would have had the right to take that child with them should they choose to do so.
Excuse me. You know, that's after a whole process. What you did was you separated the children from their parents before any kind of process even began. So I understand that once the process and all of that, then if appropriate, you would reunify the children with the parents. But in the first instance, that was not what was contemplated. So basically what I get is that what was happening was that with the separation of the children from their parents, they were immediately deemed unaccompanied children and sent to Health and Human Services, where in Health and Human Services, under the normal processes, would have tried to find sponsors or someone to take care of their children. Hence, there are some 11,000 children within HHS's custody. So it's very clear that that the administration had no plans to reunify these children as required by the courts. Now, Mr. Albans also testified that Homeland Security's family residential centers, FRCs, are like summer camps. I'd like to know whether all of the panel members are familiar with Homeland Security's FRCs. Ms. Provost.
Ma'am, I do not have I have not been to one of the FRCs.
Commander?
Ma'am, I've never visited a family residential center. I'd have to defer to my colleague from ICE. He would know them best.
Mr. McHenry, are you
I've
familiar?
never been to an FRC either.
And what about you, Ms. Higgins?
Yes, I've been to both Dilley and to Carnes.
So since these are described as family residential centers, and I would ask this of you, Ms. Higgins and Mr. Albans, would you send your children to these centers? Ms. Higgins?
I certainly think that in general practice, people would prefer to be free to move about. I can tell you that the centers that I saw did, as described, have schools and.
So you would send your child to these centers?
It's very,
no?
that's a difficult question to answer. It's difficult to put myself in the position of an individual who takes a dangerous journey in which their child can be harmed.
Well, these are deemed
let alone whether I would send my
summer
children.
camps. So, you know, Mr. Albans, would you send your child to FRCs?
Again, I think we're missing the point. These individuals are there because they have broken a law. There has to be a process.
They have broken a law only as deemed so by the president with his.
No, ma'am, they're there for violation of Title 8 of the Immigration of the U.S. and Nationality Act. Okay, they're U.S.C. 1325. That's illegal entry is both a criminal and civil violation. They are in those FRCs pending the outcome of that civil immigration process. They have broken the law.
Well, these are mainly, my understanding is that under the zero tolerance, these are no longer civil proceedings, but in fact, were criminal proceedings.
They were both,
so?
they were criminal proceedings when the Border Patrol prosecuted them, but at the conclusion of that process, once the individual came into ICE custody, they would go through administrative proceedings.
I'm confused.
Okay.
So the
criminal
law that-
criminal proceeding is an individual being prosecuted for the criminal violation of improper entry.
And that was the zero tolerance policy, right? That everyone would be prosecuted in a criminal proceeding. Is that not right?
That is correct.
Thank you. Okay. Now, I know that there are a number of children. The last report from the court, this is a proceeding before the San Diego court just this month. And at that time, there were 711 children who were deemed ineligible for a number of reasons, but 120 of these children was because the parents waived reunification.
Yes, ma'am.
And some 431 were because the adults their parents had already been deported. Didn't the court tell the administration to find these 431 deported parents and reunify them with the children?
Although There are limits to what I can say about it because it's currently in court.
But didn't the
We
court tell the administration that you better find these parents who have already been deported?
We are actively working to make contact with all of those parents. Yes, ma'am.
And how many of them have you found so far who have already been deported?
So I don't have with me the number that we've contacted yet, although we can provide
It's
that.
pretty challenging, isn't it? Once you've already deported them and you don't even know, we don't know where they were deported to. They were not necessarily deported to the places in the country that they came from, et cetera. So it's quite the challenge. Now, with regard to the parents who waived a reunification with their children, 120 children.
Yes, ma'am.
Were these knowing waivers? Because there have been allegations that these parents, some of whom didn't even know that they were waiving the rights to be reunified with their children. There were language issues. I want to know whether we can be assured that these were knowing waivers by their parents. Is there something that you can show us that says that they fully understood what was happening to them before they signed or one assumes they actually signed waivers?
So ma'am, let me clarify, because there's two different things being discussed, and one is the written waiver process is discussed prior to a parent leaving the United States, but that's separate from the HHS process that we did face-to-face interviews with parents to determine if they wanted reunification. I'll explain why. Because many parents have made this journey to deliver their children here because that is the desperate last act of a parent trying to take a child out of some of the most dangerous places to raise a child in the world. Honduras has the highest youth murder rate on earth for any country that is not actively at war. So although might be unfathomable to understand why someone, when presented with the opportunity to be reunified with their child, might say no, it is unfathomable until you've walked in those parents' shoes. So the reality is, because we knew that some parents would say, no, I don't wish my child to be reunified, I want my child to stay in OR care and be reunified with my sister, whomever, then we did face-to-face interviews to ask the parents, do you want your child to come to you? And most of the parents said yes. Some parents said no, and when they said no, we asked them to complete a standard OR form called a letter of designation, which is a way that a parent expresses a preference for who they would like their child to go to, usually a close family member.
So my only question is whether these waivers were knowing, because if they were knowingly waived because of the circumstances, I certainly understand that. And in fact, because of the Attorney General's decision that certain kinds of violence in their countries will no longer be considered as part of their asylum argument, then, you know, Mr. Commander White, you just said they come from these horrific conditions. That's no longer deemed an appropriate factor to consider, Ms. Higgins. That's all I have to say. Thank you.
Before I recognize Senator Cruz, who will be taking the gavel so that I can go vote. Ms. Higgins, I have just a quick question for you. Would you send your child 300 miles with a group of people that could include gangs, drug traffickers, or human traffickers over a 3,000-mile journey to our border?
So again, I just think it's incredibly difficult to put myself in the shoes of individuals who are in those situations. So
Thank you. Senator Cruz.
Thank you, Mr. Chairman. Thank you to each of the witnesses for being here. Thank you for the incredibly important work you do. These are challenging times for our country, and the work you do, particularly the Border Patrol agents, the agents of ICE, is difficult. It's important. I will say, Mr. Albence, in particular to the ICE officers, I want to personally thank the men and women that you serve with, who risk their lives each and every day to keep this country safe. And in the political environment we're in, there's some in Washington who have taken to vilifying and attacking ICE, and on behalf of 28 million Texans, let me just thank you for the work you do every day keeping us safe.
On behalf of the 20,000 dedicated men and women of ICE, I thank you.
And I would certainly express the same to Border Patrol. I've spent a great deal of time with a great many of your agents, and they are heroes who put their lives on the line on a regular basis.
Thank you, Senator, and on behalf of our 19,000 men and women, I thank you.
Ms. Provost, the first several months of 2017, we saw a significant decrease in illegal immigration. Unfortunately, that decrease has essentially evaporated in 2018. Why do you believe it was that the numbers went down so dramatically, roughly a 70% decrease in the first several months of 2017, and why have they begun increasing again now?
Senator, in my personal opinion, I believe that the numbers did go down initially when the new administration came into office, and discussions about border security became front and center. In regard to the numbers now going up, and we are currently at 22% higher compared to this time last year. At some point, once individuals see whether or not we do act and are hard on immigration, hardline on immigration, at some point in time, they start coming here. Then they speak to their family members and other things. Those are factors, as well as many push factors from the countries that they come from. There are numerous pull factors, some of which we have discussed today as well, whether it's economic or whether it's the fact that court decisions impact that. So those factors, eventually, the numbers started creeping back up on us.
Now, there's been a great deal of discussion of children coming illegally and children being detained, but children also coming through human traffickers. As the men and women on this panel know, this is not a new problem. We have tragically seen thousands upon thousands of children coming for a great many years. Ms. Provost, let me ask you, when kids are brought into this country by human traffickers, what kind of treatment do they get in the journey, and what kind of abuse are they potentially subject to in the process of coming here illegally?
Senator, as you know, it's a very treacherous trip that they are making. There are numerous factors that impact. Obviously, the transnational criminal organizations, they treat all people like commodities. It's about money. It's not about the care and well-being of those individuals. We apprehend large groups, both in stash houses, in deplorable conditions, as well as riding in tractor-trailer trucks, which, as we know, in San Antonio just a year and a half ago, we had that tragedy. So these individuals are put at risk day in and day out, and that's just what happens once they are along the border, not to mention the trip up. There are cases of rape, of abuse, of all different types of things that are happening to these illegal aliens that are coming, making that trip to the country.
As you know, there is widespread agreement in Congress on both sides of the political aisle that families should not be separated, that the best place for children is with their parents, with their moms and dads. At the same time, I believe it's imperative that we also enforce the law, that we should not be adopting policies that effectively mandate catch and release, because that only serves to attract more people here illegally and to ensure that even more children will be subject to the abuse, to the horrific treatment that human traffickers subject them to. I've introduced legislation that would mandate families stay together and at the same time would enforce the law and prevent a return to the policies of catch and release, and we're engaged in ongoing negotiations with Senate Democrats to see if there will be bipartisan agreement behind that legislative effort. I'm hopeful and optimistic. Mr. Albence, can you share your thoughts about the consequences of catch and release and what it does to levels of illegal immigration?
Well, again, I think going to the Chief's point previously, I think you saw that initial dip after the middle part of last year when there was concern that the laws of this country would be rigorously enforced. Unfortunately, what the smugglers and the illegal aliens learned was that the loopholes that exist, which facilitate this process and forces us to release these individuals shortly after apprehension, haven't changed because they need congressional action to do so. And absent
And Mr.
that,
Alberts, can you, in your answer, discuss the implications, the consequences of the Flores consent decree and how that constrains your enforcement abilities?
absolutely. The biggest issue is that when we have a family held together, the Flores decision, which was from the settlement agreement from 1997, and then reinterpreted by the judge again in 2016 and applied the UAC requirements to family detention, even though family detention did not exist in 1997. It requires us to release those individuals within 20 days of taking them into custody. And we cannot effectuate the entire immigration hearing process, credible fear process, asylum process, within that 20-day period. As a result, we have no choice but to release these individuals out into the communities, and most times we don't see them again.
Thank you.
Thank you, Mr. Chairman. I could not agree more with your opening statement, Chairman Grassley, that the administration has mishandled family separation, and in some ways I'd say we sit here now in the middle of a humanitarian crisis, largely of the Trump administration's creation. The zero-tolerance policy has led to the separation of thousands of children, including infants and toddlers, from their parents, and has intentionally inflicted untold amounts of human suffering. As a father and a person of faith, I find this policy unconscionable, and the administration's efforts so far to reunite children with their families, sadly, inadequate. I'm frustrated that despite repeated inquiries across a broad range of senators and congressmen and women, we've not been able to get timely, full, and accurate information about the process and about where we stand. So first, Mr. Chairman, Senator Langford and I have joined with a dozen of our colleagues, 14 members, 7 Republicans, 7 Democrats, to request information. This is a letter we're sending to Attorney General Sessions, to Secretary Nielsen, and to Secretary Azar, just asking for basic details and regular updates on what are the facts, how many children, what ages, where being detained, where being reunited, on what timeline. I'd like to enter this for the record, if I might, Mr. Chairman.
Without objection, so ordered.
And could each of the 5 of you simply say yes or no? Are you committed to getting timely responses to Congress in response to broad and bipartisan requests for relevant information about our progress towards resolving this separation situation?
Yes, Senator, I will take this back, and we will work on getting that information to you.
Thank you, ma'am.
Yes, sir, absolutely.
Thank you, Mr. Albans. Commander White?
Yes, of course.
Thank you, Mr.
Yep.
McHenry.
Likewise, we'll take it back and see what we can provide.
Ma'am?
Yes, Senator.
There are some disturbing reports in the press that individuals who are seeking asylum have been misinformed or even misled to give up their legal claims to try and get their children back. An American Immigration Council attorney testified that there are dozens of individuals that had been interviewed who felt, and I'm quoting, coerced into relinquishing their rights, or who appeared totally unaware that they had done so. Some who were even adamant that the paper they had signed was one that allowed them to choose to be reunited with their children, when in fact the form they signed had the opposite effect. Mr. Albans, could you produce to me and my staff copies of the forms that ICE has been giving to parents over the last 3 months?
We have the form that was as part of the Ms. L case that the ACLU developed and approved by the court, that we could certainly give you a copy of that one.
That'd be helpful, because there's a lot of stories, both sides, assertions, both sides, that these are folks who are well-informed and who are making a responsible decision to return to their countries of origin and leave their children here. And there's some very disturbing reporting that the opposite is the case. Mr. Albans, are parents given the opportunity to consult with a lawyer and their children before they sign a form waiving their legal rights to be reunited with their children?
As required in the Ms. L case and utilizing the form we discussed, there is a 48-hour waiting period in which the individual is allowed to contact an attorney. You may contact the ACLU. We have signs posted in our detention facilities which advise them of that right and the way to do so. It even allows individuals who are not actually members of the class to still make that contact if they do so desire.
Are they able to contact their children?
They do have contact with their children, whether they choose to do so at this time and ask their child their opinion. I can't speak to that, but they do have regular contact with their children that are in ORR facilities.
Because one of my concerns, Commander White, has been reporting that strongly suggests that children and parents who are separated, in some cases by thousands of miles, don't have a chance to communicate before parents are forced to return to their country of origin, leaving the children bewildered as to what's happened to their parents. Is that the case?
So, sir, let me let you know, first of all, what we do to provide contact with family members to children, and second, about the mental health supports we have with children to cope with this situation, because it sounds like your question touches on both. So first, every child in ORR care within 48 hours of arrival is given the chance to call family members either in the United States or in home country. They're also allowed a minimum of 2 phone calls a week, and many children get significantly more than that. Obviously, parents who are currently in detention status are harder to call in some cases than people who have a cell phone because they're at liberty, but there has been strong collaboration between ICE and HHS to do that. As we sent our field teams, our 200-strong field teams, to ICE detention centers to interview parents, part of what they did was, in the course of interviewing parents, they also would promote telephonic contact between parent and child right then. So we are doing what we can to have children in contact with parents. But second, I think the second part of your question is really important, which is in the middle of this are children of every age from infancy up until the day before their 18th birthday. Every child in our care has a mental health clinician. There's a 12-to-1 client-to-clinician ratio. So every single child, whether separated or traditional UAC, has a mental health clinician they see regularly. And part of what we are leveraging in the fact that this is a program designed to support children who've experienced traumas is that we are getting the mental health supports also to cope with the uncertainties of this situation for those who've been separated.
Thank you, Commander White. Let me just 2 more things before I conclude. Senators Langford and I joined Senators Bennett and Collins in a letter urging the administration to work with the faith community proactively in efforts to reunify families. I'm concerned by reports I'm getting that faith-based groups that are willing and able to provide support for reunification are getting little or no notice before being asked to provide support to hundreds of families. These are organizations that stand ready to help. Can you give them more information, more timely information or notice about when and where families will be released so that they can get the support services that will allow them to make the post-trauma transitions you're talking about?
So the specific release piece is actually ISIS, but let me clarify this. The compressed time frame required by the court required us first to do something we've never done before, which is reunification of minors with children in ICE detention, and second, to do it under an incredibly compressed time frame. And we achieved that for the eligible minors. This had the effect of meaning that children and parents are being reunified high speed. That is why those who work for Mr. Albence and the people on my team were working 24/7. It's why for 30 days I worked 18 hours a day. We were doing everything that we could to move these children as quickly as we could. The 2 NGOs who worked with ICE to provide safe entry into communities for released parents, we did what we could to facilitate giving them that time frame to provide that assistance. But this was a consequence of the size and speed of this reunification effort.
Well, and I'll say in closing that the entire process is, I think, a consequence of the Trump administration having implemented a cruel policy of intentionally separating families without a coherent plan in place in advance for reuniting them. And I respect and appreciate the very hard work you've all gone through to comply with the court order, but it seems clear to me from what I've heard in this hearing that there wasn't sufficient thought given in advance to what would happen in terms of reuniting children and their parents were this policy reversed. This is, I think, the 3rd immigration crisis that's been created by this administration, the travel ban, ending DACA, and the zero tolerance policy. I'm looking for updates from this administration until the number of children forcibly separated from their parents returns to 0. And it's my hope on a bipartisan basis we can move to resolve the underlying legal and framework issues that make immigration such a difficult issue for all of us. Thank you, Mr. Chairman.
Senator Booker.
Thank you, Mr. Chairman. I'm really grateful that the panel is here, and obviously have met a lot of the folks that work underneath you, and just have a tremendous amount of respect for the service that they're giving to the country. But I do have a lot of concerns about the policies that we have, a lot of them stemming from the White House, that have caused a lot of harm and that don't represent who we are or our best values. I went down to McAllen, Texas recently, and the first thing I did after landing around midnight was to drive to a port of entry nearby, Hidalgo Reynosa International Bridge, and I crossed over into Mexico, walking in the dark, the length of the pedestrian bridge across the Rio Grande into Mexico. And as soon as I got there, the Mexican officials, the one guy that was there, started warning me about the danger of going further into the town, the community. I'm a big guy, but they were concerned, cuidados, está peligroso. And that wasn't my intention to go into the community. I wasn't going over there as a tourist. I really came back around to walk back in and see how people who were looking to present themselves for asylum were greeted. And I was a bit surprised because as soon as I got there, instead of being at the point of entry, there was folks, 3 Customs and Border Patrol agents that were stationed right there at the middle of the bridge, right on the border. And I had a conversation with them. They didn't recognize me as a United States Senator, but I just had a conversation about why they were posted there, what they were doing, and they basically told me they were turning away people that were presenting themselves for asylum. Again, into that community that I was told that was dangerous. Their job was to prevent asylum seekers from stepping foot on American soil and presenting themselves in the legal manner that our laws say that they are allowed to do. They warned me about my safety, which sort of surprised me. Again, you're turning away children, mothers back into that community that you say is not safe for me. And I wondered about that. It really was difficult for me as an American to see us turning away people trying to seek asylum from being evaluated in a systematic process that I thought existed, and instead being pushed back into a dangerous environment. And so we've all heard these reports of people who are seeking asylum, who attempt to legally claim asylum at ports of entry being turned away, and it's unclear for me exactly why. Is this a space issue, which I've had some great conversations with CBP folks that talk to me about the issue of having enough space. And so I'm wondering, in all of our processes, about how we're prioritizing such that it could reflect our values and keep us safe. I live, one of my colleagues talked about minority communities that see the danger. I live in an inner city. I live in a predominantly African-American community, in a majority African-American city. I have had shootings on my street in the last 2 years. I am concerned every single day about safety in our country. And I think we should be focused on the safety of our citizens. But what I worry about is those folks that pose absolutely no threat whatsoever, that we're not figuring out a way to get our resources focused on our values. Safety first, and making sure that we create legal processes, because with the fact that we're turning people away creates more danger, not just for them and their families, but also pushes more people into breaking the law and getting chewed up into our systems in ways that we don't want to. It's a moral question to me about prioritization. And so my questions real quick are, first of all, I'm wondering, and maybe Mr. Albans, you can answer this, are you coordinating with Customs Border Patrol to prioritize using beds and resources so that there are resources available for legal asylum seekers instead of using the beds to lock up people who are otherwise law-abiding citizens?
So we do. We manage a diverse portfolio of beds. Obviously, we have our family residential centers. We have adult detention centers. We have a command center in San Antonio that helps manage those beds. We have officers stationed at the CBP command center here in D.C. that helps manage those beds. I have a whole division in headquarters that's solely dedicated to the management of beds.
I guess I'm not talking about the beds you have available. I'm talking about the prioritization. In those beds, you have a lot of people that don't pose a threat. ICE's own data shows, according to their classification system, they describe that more than half of the population in ICE custody are posing zero community safety risks, according to the National Immigrant Justice Center. So it seems to me that
a lot of those individuals are subject to mandatory detention under the Immigration and Nationality Act. Individuals that are asylum seekers at the POE, unless they are paroled in, are subject to mandatory detention.
So when you say that they're individuals, I'm sorry to interrupt you, I have very little more time, but you're saying that some of them are asylum seekers. And so my question is if you are working with CBP, can't we be doing more to make sure that there are more beds available for those asylum seekers? Isn't there a better
We
way to
have,
prioritize?
we are continually looking to expand our bed capacity. We are generally between 97 and 99% full when it comes in terms of our adult beds, but we're always looking to expand capacity.
And so,
But we would need the funding to do that, too.
right, and that's great, because that is a policy issue. But I guess I really worry that, ICE agents have arrested about 4,143 undocumented immigrants without a criminal record each month under this administration. That's a lot of resources going after people and that pose us absolutely no threat. While the concerns of my Republican and Democratic colleagues about people who are posing threats or people who are trying to come here through the legal means who are being turned away and often end up coming through illegal means, gumming up the system, there's got to be a better way to prioritize it. And I actually question what you need Congress's help with. You need Congress's help, perhaps, to provide more resources for beds. And if that's the case, I'm gung-ho to help out with that. But as Senator Leahy said, you call your tip line. And that reflects your priorities right there. I mean, he said that the very first thing they want you to do is report on your neighbor. It's press 1 for reporting suspected undocumented immigrants, not violent people, not terrorists, not gang members. The very first thing. You have to go pretty far down. Terrorism is number 4. I would think that should be number 1, frankly. Reporting crimes against children was number 6. Reporting gang activity is way down at number 8. Now, as a guy who, again, lives in a city with a lot of undocumented immigration, we see that in our cities across America, your prioritization seems to create this chill, this fear. So now the people in my city, they're afraid to report crimes or undocumented immigrants. This prioritization seems problematic. And so, ICE should be in the business of catching criminals, not encouraging Americans to report on their neighbors for possible civil immigration offenses. And it's this prioritization to me that is disturbing, because I actually think, and I've seen this with the drug war in America, we have literally tens of thousands, hundreds of thousands of people locked up right now in this country for low-level drug crimes, many of them for doing things that 2 of the last 3 presidents admitted to doing. Think about those resources that could be used in communities like mine to keep people safe.
Right. Well,
and I'm done now. I just want to ask you the last question. Can't you do a better job prioritizing the people that are threatening our country, as opposed to locking up so many people that pose zero threat? Can't you re-examine your prioritization, that even your tip line, for God's sake, can encourage Americans to help you make us safer, and not continue to round up people that take resources away from the really dangerous situations in our country?
I hope you can give a short answer.
I'll do my best. So what I can tell you is that 9 out of every 10 people that we arrest has a criminal conviction or has been charged with a criminal offense. I can tell you that the aggregate number of convicted criminals that we've arrested has risen for the past 2 years. So we do prioritize, but at that same point, when we encounter individuals that are here unlawfully during the course of our enforcement actions, prioritizing those public safety threats, we are not going to turn a blind eye to them. The other largest group of individuals that we arrest are individuals who have already had their day in immigration court, have exhausted due process, and are fugitives, meaning they've ignored the judge's order, or there's somebody that's been previously arrested and deported and has returned in the country, which, as you know, sir, is a felony. So 92% of the people we arrested last year fell into those categories. And if I could answer your and it's going to be speculations, I don't know, because the tip line doesn't fall under me, but we've been working with the tip line to prioritize and categorize the types of calls that come in there. And ERO, which does the civil enforcement aspect, has been working with the tip line. Again, I'm speculating, but I'm thinking they're doing that so that they can move those cases over to ERO for referral, while HSI keeps the other categories, because they have responsibility for those.
Well,
but I will find out and get back with you.
A question for the record, if I can, because that doesn't jive with the data that's
Please make it quick.
The QFR for the record is just simply, if that is true, then why does his own data show that half the people that he's detaining pose absolutely no threat whatsoever? That doesn't sound like to me you're prioritizing your resources for public safety at all. In fact, that you're creating more safety hazards because you're creating chills and fears amongst immigrant communities to actually report crimes and work with local police. So I'd like that for the record.
Yeah, Senator Blumenthal.
Thanks, Mr. Chairman. Thank you for your patience in being here, and thank you for the service of the many men and women who diligently seek to enforce our laws. Let me ask this panel, who here thinks that zero tolerance has been a success? You can just raise your hand if you think it's been a success. Who thinks that the family separation policy has been a success? Raise your hand. Who here can tell me who is responsible? Which public official, which member of this administration is responsible for zero tolerance and family separation? Can anyone tell me? Who's responsible? Nobody knows?
The zero tolerance prosecution policy, the memorandum, was issued by the Attorney General on April 6, 2018.
So the official responsible for zero tolerance is the Attorney General of the United States, acting presumably with the approval of the President of the United States, correct?
He is the one who issued the memorandum on April 6, 2018. It's an extension of an earlier memorandum he issued in 2017.
Did anyone, any member of this panel, say to anyone, maybe this isn't such a good idea? Commander?
During the deliberative process over the previous year, we raised a number of concerns in the ORR program about any policy which would result in family separation due to concerns we had about the best interest of the child, as well as about whether that would be operationally supportable with the bed capacity we had.
Now, I'm going to translate that into what I would call layman's language. You told the administration that kids would suffer as a result, that pain would be inflicted, correct?
Separation of children from their parents entails significant risk of harm to children.
Well, it's traumatic for any child separated from his or her parents. Am I correct? I say that as a parent of 4 children.
There's no question that separation of children from parents entails significant potential for traumatic psychological injury to the child.
And would I be correct in assuming that the answer to you was, in effect, that's the whole purpose of the policy, to inflict pain so as to deter asylum seekers from coming here, correct?
No, sir, we were advised that family separation was not the policy.
Family separation just happened to result from zero tolerance without anybody knowing in advance, even though you raised the concern, correct?
Yes, we raised concerns about the effect on children as well as the effect on the program.
And what was the answer?
At no time during the time that I was in ORR was there an actual policy announcement of family separation. It was merely a discussion of possible future consequences.
So there was awareness that it would be the consequence, correct? You raised it.
I did raise it.
And I'm asking again, what was the answer?
The answer I received is that that family separation was not a policy. That there was no policy that was going to result in family separation.
It would be a consequence of the policy, but
correct.
Not the policy.
No, that I was advised that there was no policy which would result in separation of children from family units.
Are you satisfied with the amount of care and counseling that is being provided to these children to deal with the trauma and the pain of their separation from their parents?
Yes. The children in ORR care each have a mental health clinician.
Well, I know they each
receive
have a mental health
services.
clinician. Are you satisfied that they are receiving sufficient care, or do you believe that maybe those clinicians are overworked, overburdened, that there should be more of them?
I believe that children are receiving sufficient care.
Let me ask whether anyone here has authority to end the appeal of Judge G's decision that the Flores settlement should be continued. Does anyone here have that authority?
The Department of Justice makes the litigation decisions. I personally wouldn't have that authority, but the department would.
And can you commit to me that there will be reconsideration of the department's decision that Flores should be sustained?
As I indicated in response to a prior question, the department is considering its options in light of the most recent ruling.
What are the number of children under 5 who have been reunified?
Sir, I don't have that number with me, I'm sorry.
Is it less than the full number of 102, I think it was, that were separated?
Yes, sir, some minors could not, were not eligible for reunification. They couldn't safely be reunified.
Do you know the number?
I don't know the number, although I'm sure we have it and can provide it.
And of those 431 total, how many eventually of them do you expect will be reunified?
You're referring to the total of the minors whose parents have been removed from the United States?
Correct. Is there any prospect that they will be reunified? And what number?
There's no way that I could say what number it will be because it hasn't happened yet. We are working on strategies to effect reunifications for all of the eligible ones. A number of parents may elect that their children remain in the United States.
When parents are put in detention facilities, are they permitted to retain their telephones, their cell phones?
Not at the facility itself, no.
How do children reach their parents?
I can speak to our capabilities at the detention facilities. Commander White spoke with very well about the process they utilized. Our individuals are allowed phone calls during the course of their detention. We have a contractor that provides low-cost, if not free calls. Once an individual is booked in, they always get a free 5-minute call domestically or internationally. We have worked very closely with Commander White's people during the course of this process to ensure that communication occurs on a routine and regular basis. They've surged resources to our facilities to help facilitate that communication.
I'm going to finish because my time has expired. I just want to say that there is now total consensus on both sides of the aisle that this zero tolerance and family separation policy, and it has been a policy, as you indicated, Commander, it was clearly foreseeable as a consequence of zero tolerance. It was part and parcel of the policy to inflict pain so as to deter asylum seekers from coming to this country. Now, we have it at the highest levels because General Kelly himself and other top officials indicated that deterrence was an objective. And it constitutes, as I have said, kidnapping or child abuse. And ultimately, I hope that there's a lesson here. But right now, there seems to be no prospect for reunifying many of the children who are still separated from their parents. And I welcome any response, either now or in writing, depending on whether the chairman will
Do it in writing. Senator Harris.
Thank you. Mr. Chairman, you know, it is clear that the folks that are before us now are not the shot callers. They are following orders. They are carrying out a policy that clearly was not of their own making. I was heartened that when Senator Blumenthal asked the question, eliciting anyone to raise their hands in defense of this policy that was about separating children from their families, none raised their hands. And that being said, I believe that we need to call this policy what it is. It is a policy that is about the United States government committing a human rights violation. And I will repeat what I have said weeks ago. I believe that those who called and created this policy and implemented it, including Secretary Nielsen, should step down, because this has been a policy that has not only wreaked havoc, it has, for probably the entire rest of the lives of the children who have been affected, will cause them harm and damage. That being said, Commander White, as of today, what is the current number of parents outside of the country who were separated from their children and have yet to be reunified? And please don't give me the number 431, because that was the number from last Thursday.
So, ma'am, we don't have the parents, we have the children, but I'll talk to you about the number of children who have parents departed. 81 of those children have been discharged, and 429 children remain in care whose parents have departed the United States.
And what is the deadline by which we are, and that you are, going to reunify those children with their parents? Is there a deadline in place?
My team is working to effect those reunifications.
Is
Frankly,
there a deadline in place?
we do not presently have, to my knowledge, a deadline in place. 3 different federal district courts are now involved in what we can do and what we must do.
Don't you believe that that we should be held accountable to ensuring that all means necessary are put in place to ensure that these children are reunified with their parents, and there should be a deadline set to make the urgency of the matter clear to all involved?
Ma'am, it is absolutely my heartfelt conviction that we must reunify those children with their parents. Yes,
Will
ma'am.
you commit to creating a deadline by which that should happen?
The deadlines will be imposed by courts, and we will execute them. My preferred deadline for my team is absolutely as quickly as humanly possible.
Are you saying that you don't have the authority to create a deadline?
I'm saying that if I could have reunified all those children with their parents by yesterday, it would be done. We are operating under, we are operators and work within the world of what is actually operationally achievable.
Are you under a consent decree?
I'm sorry?
Are you under a consent decree by the court?
I'm going to have to defer to DOJ to characterize our current legal situation.
And what efforts, if any, is the government making to provide phone and video contact between these families while they are in detention facilities?
So as we indicated, for the children in our care, we work to provide them with unimpeded access with phones to contact their parents.
Is it a policy that that they are not to be charged to make these phone calls? You're aware that there's an expense associated with making those calls.
No.
Who pays that expense?
Minors who are in OR care, when they call family members, whether those minors have been separated or otherwise, those calls are paid for under the appropriation that Congress provides for the UAC program. That is part of the care of the child.
What about the calls that the parents make to their children? Who pays for those calls?
If they are in one of the facilities that has access to our free platform, then those calls are at no cost to the individuals. If not, the individual will have a minor costs associated with that call, depending who that individual is calling. Calls of family members, emergency situations are not charged. Calls upon booking into a facility, transferring facilities are not charged.
Have you visited the Otay Mesa detention facility in California?
I may have been to Otay once. I'm not positive.
I've been there.
I think I've been there once.
And I've met with the parents there. And I was told by the people who are running that facility, who most are contract workers, that the calls that those parents would make to their children are free. However, when I sat with the mothers who are at that detention facility and asked them, I found out that they're being charged 85 cents a minute for those phone calls. I further found out when visiting that detention facility that when those parents are there and perform labor, such as cleaning toilets or doing laundry, they are paid $1 a day. Are you familiar with that policy or practice?
Many of the individuals that are in ICE custody are eligible to apply and work in a voluntary work program. It's not mandatory, it's voluntary if they choose to do so. Many do choose to do so just to pass the time while they're awaiting their hearing or their removal.
Do you think people voluntarily choose to clean toilets to pass their time? Is that what you're saying?
I can say that we have a large number of individuals within our custody that volunteer to work on the work program. Details,
To
yes.
clean toilets? Sir, is that what you're saying?
I don't know every task that these individuals are assigned, but again, it's voluntary.
So are you familiar with a practice, at least at that detention facility, that is to pay the detainees $1 a day for labor performed in that facility?
I'm not particularly familiar with that facility. I can certainly find out when I get back.
Please do, and if you could report back to this committee. How many pregnant women have been detained since January in any facility being run by your agency?
I don't have since January. I can give you the fiscal year number year to date, which would be as of July 21st, and that's 1,395.
And what is the policy in terms of transferring them to a less restrictive facility, if there is such a policy, based on the term that they are in their pregnancy, and in particular around the 3rd trimester? Is there a policy?
Yes, ma'am. We do have a policy regarding pregnant detainees and their care. Its policy was changed last year to comply with the President's executive orders. In practice, the only effective change is that no longer are pregnant women given the presumption of release. We'll look at every case on a case-by-case basis.
Which was the previous administration's policy, to allow pregnant women to be in a less restrictive detention facility.
They'd be less restrictive, or which we still utilize, or sub-released. So the number of pregnant detainees that we have right now is not vastly larger than it was in the past 2 years.
But the conditions and terms by which they are detained is vastly different, as you said, in terms of the policy change.
No, we're using the same detention facilities now that we were using in 2015, 16, 17. We utilize the detention
No
facility.
longer with the presumption, as you've said.
No,
that there will
presumption
be
of release. No, presumption of release. Correct, ma'am.
Right. And then I've heard of at least 2 cases recently where women were going into labor while they were in detention. Are you familiar with those cases?
I'm not.
And what protocol is being followed or has been promulgated for women who are going into labor while at your detention facilities? I'm also concerned, are they being accompanied by ICE officers to a hospital, or are they, is the anticipation that they will give birth in a detention facility? And do you have any policies in place regarding them being shackled? Do you know of any of that?
Yes, so our policy with regard to shackling, it's in our PBNDS 2011, that we do not shackle women that are in active labor.
What does active labor mean?
Well, they're in labor, ma'am. But if they're 6 months pregnant and not in labor, then that would not be active labor.
So is there a policy regarding pregnant women being shackled if they're not in active labor?
I'd have to look exactly to see what it specifically says. There are times when an individual is being transported where they would need to be handcuffed for their own safety, as well as the safety of the officers and the other inmates that are detainees that are being transferred. Absolutely.
Okay, if you can follow up on the number of women that are in their 3rd trimester who are currently housed in your detention facilities, I'd appreciate that. Thank you, Mr. Chairman.
Thank you. Before I say meeting adjourned, thank you all very much for participating. We hopefully answered a lot of questions. You'll probably get questions for answer in writing. Some of you have received them orally already. There'll be a week for members to submit questions. Hopefully you'll get the answers back just as soon as you can. And we thank you very much for your participation and your authority that you have. Meeting adjourned.